I'm going to preface this recording with there's a lot of bullets and numbering going on. And it might be confusing hearing it from a computer read it, but this is my outline for corporations.
Sole proprietorship 1-1. The sole proprietorship, 1 sole proprietorship elements, 1. No separate identity from its owner. 2. Unlimited personal liability for obligations incurred in the conduct of the proprietorship's business. Key concerns 1. Law of agency. 2. Internal structure. 3. Liability of owners. 4. Conflict of interest. 2. Agency. 2. Restatement third of. Agency SS 2.01 implicated by employment of one person to act on the employer's behalf. A. The authority of an agent. 2. Agent, person by mutual assent, acts on behalf of another and subject to the other's control. 2.
Citation.
Agency must be for lawful purpose effort. Principal, for whom he is acts third person, with whom the agent deals or purports to deal on employer's behalf. Disclosed principal, third person is on notice both that is acting on behalf of a principal. Partially disclosed, third person is on notice that agent acts on behalf of a principal, but principal's identity is unknown. Unidentified, third party has no notice that agent is acting on behalf of principal, rather than on his own behalf. Speed via Mohana, 3. Trial court grants doctor's motion for summary judgment on evidence that he is released from medical malpractice. Action. On appeal. Defendant prevails because Bernie had authority to release doctor from liability on behalf of his client. The court held. Actual authorities. 1 from the lion and by the client. On the rule of actual. Actual authority. Attorney of record had authority enter into agreement. For client. Notes on sources of agent's authority. 5. Personal liability for acts of agent. In tortious act. O plaintiff had right to control manner and means of agent's performance in scope of employment. In contract. Law O agent acted/purported to act on plaintiff's behalf and had actual apparent authority or inherent authority to do so. O mistake doesn't negate actual authority. Black small square as long as plaintiff put in motion transaction, she stood to gain from. Black small square third party recovers from agent. Who recovers from principal. Black small square, therefore, third party action against plaintiff is more efficient. 3. Public policy for fairness charges principal a commercial cost for convenience and principal can bear cost better than agent. The principal can protect himself by disclosing agent's authority. Principal's loses are expected because no agent in impeccable. Black small square agent contract. Differs from meeting of minds. Conventional. Contract. Because it's ambulatory. I.e. subject to agent's reasonable interpretation. At the time agent acts based on what agent knows or should know. Temporal focus and quote. On various factors. Black small square variance, future events that agent acts on outside authority because he reasonably believed are to principal's benefit actual authority by implication. Expressed. And implied actual authority/agent authority. Implied equals. Inferred. From words. Customs or relations. Incidental authority. Authority to do acts reasonably necessary to accomplish an actually authorized transaction salient. See Restatement, Section 27. Power of position. Manager, treasurer, etc. Apparent authority can be by appearance. Those who know of the appointment place apparent authority to the agent to do things ordinarily entrusted to one occupying such a position regardless of unknown restrictions imposed on a particular agent. RSTMT 27 Comment A. Agency by estoppel. Page 10. See Restatement 3rd Section, 2.05. Concept is now subsumed in apparent authority. O. If agent induced third party to change position reliant on apparent authority because black small square intentional / careless creating of such belief. Black small square inducement and no reasonable steps to make facts known to third party. Apparent authority is what the opposing third party would assume and accepts without knowledge. Otherwise, client or principal. Plenary authority. From the perspective of opposing party, in the absence of knowledge of express restraints on attorney's authority, the opposing parties deal with the attorney as if with the client, and client will be bound by the acts of his attorney. Within his scope of apparent authority. Inherent authority, agent may bind a principal in certain cases, even when the agent had neither actual nor apparent authority. O. General agent.
Inherent.
SS 161. 4. O. Special agent. See Restatement 164 for types of agents. Morris Oil Company v. Rainbow Oilfield Trucking Incorporated, 14. Case involves undisclosed principal in agency law rules, Section 194, 5. Agent will subject principal to liability if undisclosed and transaction is usual and necessary. Plaintiff oil to defendant and was awarded judgment for garnishment of $13,000 from Dawn's the principal of its agent, Rainbow. Dawn and Rainbow had a limited agency contract referred to as a terminal, trucking, management agreement, in which Rainbow would not be an agent empowered to incur debt behalf of and other than in the ordinary course of business relative to the agreements. Rules of Agency. SS 316/194 imposed liability on principal, regardless of third parties' knowledge of restriction on
I just
agent.
watched Christian McCaffrey
Rule.
score a
SS
touchdown
194
in the
agent
fourth quarter
subjects
against the Cowboys.
principal to liability for acts done on his
As a
account,
lead.
if they are
A lot
usual
of
or
neglect.
necessary, even if forbidden. Analysis.
Yes.
1. Ordinary business. 2.
Ordinary
Knowledge not
business.
charged to third party, i.e., undisclosed agency. 3. Ratification by principal when third party informed him and he didn't dispute. Termination of agent's authority. When agency and power is terminated wrongfully, it creates liability for damages. Notes on liability of agents who acted for disclosed, partially disclosed, or undisclosed principal. 18. Disclosed principal, not agent, subject to liability. Restatement. 3rd Section 6.01. Because third party expected that outcome. Undisclosed principal, generally agent found 2 contracts in principal.
That sucks.
Traditional majority rule. Action against either exonerates alternate party. Partially disclosed principal, general rule, both agent and principal are bound to contract with third party, but if plaintiff unknown then agent's creditworthiness, likely the third in properties, expected payer/payment method. 5. Note on ratification. 19. Ratification. If agent didn't have actual apparent or inherent authority, the principal is liable when third party has knowledge of material facts. 1. Principal affirms agent's conduct by manifesting intent to treat it as authorized.
It's a ratification.
And/or 2. Engaged in conduct that is justifiable only if he has such intention. Express ratification. Plaintiff manifest intention to treat agent's conduct as authorized. 1. Principal affirms agent's conduct by manifesting intent to treat it as authorized. Implied ratification. Restatement 3rd 4.02. Objective manifestation by the principal. Need not reach third party before with party withdrawals or materia change in circumstances. 2. Engaged in conduct that is justifiable only if he has such intention. Rationale. Ratification provides greater certainty. O. Ratification validates apparent authority. Notes on third person's liability, 21. Inverse third party liability to principal agent. Liable to third party if principal. Undisclosed. And. Unratified. O. Liability on the contract theory. Gives rise to the expectation interest of third party. O. Implied warranty theory. Gives rise to third party liability. Principal liability to agent. Duty to indemnify if agent acted with actual authority. B. The agent's tortious conduct, 22. Vicarious liability test, page 23. O. Rights. O. Societal preference. O. Scope of employment. Kautsajanis v. BBNT, 23. Case involves consumer protection claims. Relative to a auto loan. Originated in July of 1996 and off. All but $23.76. Which was thereafter referred to third party for. 6. Debt collection. In October of 1999. When negotiations broke down, negative credit reporting took place. Which compromised PL's ability to consummate a commercial real estate transaction. To the plaintiff's detriment. Plaintiff sued for libel conversion, breach of contract, fraudulent intent, in gross negligence, by vicarious liability for misconduct by attorney. At trial, a jury verdict awarded $98,000 on gross negligence and vicarious liability, and BB&T prevailed on all other claims. The case holding is that an outside attorney hired as an independent contractor create vicarious liability for their client, and the law of agency applies even if the attorney is an independent contractor. And the law of independent contractor does not apply. The rule applied is that acts of an attorney are directly attributable and binding upon their client, as supported by case law. I.E. Shelton v. Brescent and Rickborn v. Liberty Life Insurance Company. C. The agent's duty of loyalty, 26. Duty of care owed to principal. Duty to disclose owed to principal. Jensen and Meckling, Theory of the Firm, Managerial Behavior. Agency costs and ownership structure.
I'm just going to say that the reason why some of this could be written in a very choppy way is that when I originally wrote this outline, I was actually recording it aloud into the Word documents, like transcription. So some of what is said here isn't going to fit very well.
Structure, 26. Agency costs 1. Monitoring 2. Binding 3. Risk of loss. Principal may owe duty to indemnify agent. Principal duty to provide safe workplace and compensate. Tarnowski v. Resop, 27. Principal hired agent to investigate coin-operated jukebox businesses for sale. Sellers paid agent kickback that led to a $30,620 transaction for 76 jukeboxes of less than 1 year of age, and all of which being operable, which turned out to be 47 worn-down machines. In action to rescind contract, principal was reimbursed $9,500 of $11,000 down payment, but kickback unrecoverable, because the universal rural that agent keeps profits/fruit of. 7. Performance. However, attorney's fees are recoverable from the agent according to rule on page 40 from 15 AM Jur Damages SS 144. It is generally held that where the wrongful act of the defendant has involved the plaintiff in litigation with others or placed him in such relation with others as makes it necessary to incur expense to protect his interest, such costs and expenses, including attorney's fees, should be treated as the legal consequences of the original wrongful act and may be recovered as damage S. Restatement 3rd Section 8.05, Illustration 1, 30. Reading v. Attorney General, 30. English government finds out SGT profited from position by providing safe transport of alcohol through Cairo, and the Crown has valid action to usurp profits according to the rule that servant has unjustly enriched himself by virtue of his service without his master's sanction. D. Imputation of agent's knowledge, 31. Carter v. Gugliuzzi, 32. Liability imposed on real estate agency's broker for negligent misrepresentation, fraud, breach of contract, because he should have known wind patterns in NH neighborhood and should have disclosed that material fact to the buyer.
Sure.
Judgment for $30,624 damages upheld.
All the windows were broken out.
Chapter 2, Partnerships.
And this property
1.
just purchased.
General partnerships can be formed without express agreement or even any intent to form a partnership. Sharing profit and loss, proportionate interest, mutual right to control, community of interest. 1. Entity versus aggregate association of individuals. UPA chooses aggregate approach. RUPA chooses entity approach, but individual partners can be personally liable. 1. Indemnification is where the partnership pays a liability of one of the partners. 2. Contribution is where the partners pay the partnership for their share of business liabilities. 3. Partner authority. 4. Actual versus apparent authority. Recall agency analysis. 8. A. Ordinary business means either the way things are done in the partnership or standard practices in the industry. 5. Dissolution order. A. Government. B. Secured. C. Unsecured. D. Ourselves. 6. Partner's interest and partner's property. The partner's interest in the partnership is that partner's property. Assignment does not constitute full transfer of partnership interest. It's an assignment of rights, but not of the right to make decisions. Creditors of a partner can get assignment of that partner's partnership income. 7. Duty of loyalty. Recall language of Cardozo, the duty of finest loyalty owed by joint adventurers. Evidently, we need to examine the relationships and judge the conduct of the partners. Implied covenant of good faith and fair dealing. 8. Dissolution by rightful election. A partner may withdraw from a partnership will at any time with impunity. Sometimes a court might force a buyout over a liquidation. Let the business continue. 3 phases of dissolution: dissolution event, termination process, termination end. 9. Dissolution by judicial decree/wrongful termination. The economic purpose of the partnership is likely to be unreasonably frustrated. Another partner has engaged in conduct that makes it not reasonably practicable to go on, or it is not otherwise reasonably possible to carry on the partnership business. Common valuation issue, goodwill of a business, also see community property. Worst case consequences of wrongful dissolution equals damages, low valuation of partnership interest, continuation of the business without the departed partner. 10. Limited partnership. The Uniform Limited Partnership Act's formation of limited partnerships. Liability of limited partners. Ownership and control equals liability. Revised ROPA. Limited partner only liable to 3 RD parties with reasonable belief.
Third parties.
Safe harbor conduct of limited partners, okay without worry of being a general partner. 9. Limited partner liability may be enhanced if the LP is involved in the management of the business, like the GP. 11. Taxation of unincorporated business organizations. This is our introduction to double taxation of corporations. Flow-through or pass-through taxation. Election of taxation status. A master limited partnership equals publicly traded limited interests. B. Also see subchapter S. Corporation. Limited liability partnership. Limited partner liability is limited to the capital tied up in the partnership. LLPs shield partners from tort liability of other partners. Professional negligence is considered a tort claim even though it arises out of a contract. Limited liability, limited partnerships, limits the liability of general partners in the same way as in regular LLPs. Limited partners, the same as in limited partnerships. Chapter 2. Partnerships, 35. Introductory note: 35. Types 1. General partnerships 2. Limited partnerships 3. Limited liability partnerships. Legislative history. 1914 Uniform Law Commissions Uniform Partnership Act, UPA. Black Small Square revised by Nkussel in 1994. Black Small Square superseded by RUPA. 1. What constitutes a general partnership? 35. Hilco Property Services Incorporated v. United States, 35. Determining if a partnership exists without intent documented in written agreement is a fact-based analysis, which involves analysis of rights of partners and third parties to determine the intent. 10. Factors include 1. Shared profits and losses. Right to participate in control of enterprise. Analysis of intent is not subjective. UPA SS 6-7/RUPA SS 102 and 202. Martin v. Payton, 36. 1927 case in which plaintiff prevailed in judgment in special term by referee and at New York CT of Appeals in an interpretation of the terms of a complex speculative business arrangement allowing the plaintiff's assets to serve as security for 2.5 M in financing. As contingency in event of loss in light of high levels of risk, the business arrangement also conveyed interest in life insurance policy and right to appointment as business partner with various powers. Court upheld the contract and characterized plaintiff as a partner in the business. Lupien v. Malsbenden, 40. Plaintiff brings action to recover losses from a transaction for a special order race car that was not delivered. TC held investor/creditor manager was subject to partnership liability because he was actively managing the business after the disappearance of the general partner. AC affirmed based on rule, page 41, an association of two or more to carry on as co-owners in business for profits was enough to. Notes on the formation of partnerships, 43. 4 elements to create partnership when there is no written agreement. Agreement to share profits. Agreement to share losses. Mutual right of control/management of a business. Community interest in the venture. Guideposts. Non-conclusive. SS 202 RUPA. Co-owners EA have the power of ultimate control. Ex Beckman v. Farmet DC 1996. 2. The legal nature of a partnership. 44. 11. UPA SS 6 RUPA SS 102, 11, 201, 307, AC. Notes on the legal nature of a partnership, entity, or aggregate. Status, 44. Separate legal entity to hold property or legal person. UPA, AGG RUPA, entity. Name for property and name for suits. Duties applying to partners in partnership. Loyalty. Care. Fair dealing. Good faith. 3. The ongoing operation of partnerships. 47. UPA SS 18 E, G-H 19 to 20. RUPA SS 105 401 to 2 408. At management. 47. Summers v. Dooley, 47. Partners disagreed on hiring a third man. TC awarded partial recovery to the plaintiff that hired the third man. Plaintiff appealed to recover more money on theory that non-consenting defendant party ratified by accepting profits. Appeal court affirmed and charged costs to plaintiff party, holding that the non-consenting party did not acquiesce/ratify by accepting profit. Therefore, recovery limited to profit, not full EXP. Rule page 48. Any difference arising as to ordinary matters connected with the partnership business may be decided by a majority of the partners. ICSS 53-318, 8. Sanchez v. Saylor, 49. Saylor sues Sanchez for breach of fiduciary duty for failure to remit financial statements to third-party lender for debt restructuring loan. Majority rule applies to the dispute. 12. Citing Koval case law. held for breach, but public policy favors dissolution when equal partners do not agree to reduce burden on judicial system. Notes on the management of partnerships, 50. Majority rule. Any difference arising as to ordinary matters connected with the partnership business may be decided by a majority of the partners. Applied for management of PS unless contrary PS agreement defines otherwise. PS agreement may be express or implied. Voting. Partnership agreement overrides SS 18H of UPA majority rule vesting management in managing partner, committee, senior partners, or group of less than all partners. Overriding partnership agreement may be implied agreement between UPA and RUPA as follows. UPA SS 18 assumes equal rights of partners and duty to consult. RUPA page 52 SS 401 H. Duty to inform SS 401 H. Absent contrary agreement, EA partner has a continuing right to participate in the management of the partnership to be informed about the business, even if his assent is not required. However, RUPA differs on matters of ordinary course of business, mandating a majority of partners vote, and contrarily for non-ordinary course of business matters, all partners to consent. B. Indemnification and contribution, 52. Indemnification. If indemnifies a part, all partners incur a detriment in proportion to their profit/share. UPA SS 15/RUPA SS 306 allows indemnification when an individual partner incurs liability to partners' creditors and may pay liability in full and seek indemnity from partnership contribution. Right to contribution from one or more partners paying creditors to equalize losses. Note on indemnification and contribution, 52. 4. The authority of a partner, 53. 13. UPA SS 3, 4, 9 to 14 partnership is not bound by unauthorized actions of partner if third party had knowledge of lack of authority. When he has knowledge of such other facts as in the circumstances show bad faith, third party is on inquiry notice. Or if partnership agreement is filed or delivered. RUPA SS 301-6. Northmont Investment Company v. Milford Plaza Associates, 53. Partners disagree on proposed lease to extend longer than partnership. The question presented to the court is if there is authority to enter into a 99-year lease that extends the length of the partnership, and the answer depended on whether the leasing is ordinary. The court held that the holding was not ordinary. Respondent was not bound to lease at TC, and AC affirmed. Notes on the authority of a partner, 54. Rule for rogue partner. Partnership is not bound by unauthorized actions, CUPC SS 9 above. 5. Liability for partnership obligations, 56. UPA SS 9, 13, 14 to 17, 36. 15. Partners are jointly and severally liable for wrongful acts and omissions by other partners such as torts and breaches of trust. 15. B. But only jointly liable for all other debts and obligations, i.e. breaches of contract. All parties to partnership must be joined or dismissed. Workaround. Black small square 1. Common Name Statute, New York, allows partnership to be sued by its partnership entity name, and as long as partners are served the judgment can subject liability on partners' individual assets. Black small square 2. Joint debtor statutes, CA case may proceed even if some obligors are not joined. Black small square 3. JNS statutes, minority, enforce JNS liability on all obligations, wrongful acts, tort, breach of trust, breach of K, debt. 14. RUPA 305-6. SS 306. Partnership may sue or be sued under common name or in aggregate. SS 307. Limit on individual assets whereby one's to partnership assets are exhausted and writ of execution on judgment returned unsatisfied. Rule of exhaustion. Page 57. A suit against a partner based on a claim against the partnership. Partnership assets must be exhausted before a partner's individual assets can be reached. Not applicable if partnership is in bankruptcy. Enforcement in entity-like approach. Collect in aggregate-like approach. Notes on liability for partnership obligations, 56. Partnership interests and partnership property, 57. UPA-O partnership property is loaned by one partner. O partnership property is owned by partnership. O not subject to succession. O creates issues. Black small square limited power to transfer. Black small square competing creditors partnership creditor individuals creditor. Black small square dissolution sell property consider property value in partnership valuation. Black small square returning individual partners property to partner. O tenancy in partnership. No succession on partner's death. Rupa O eliminates tenancy in partnership. OSS 501. A partner is not a co-owner of partnership property and has no interest in partnership property which can be transferred either voluntarily or involuntarily. Notes on partnership property, 57. 15. Assignment. O share of partnership, not partnership property, can be assigned but with limits. Black small square transferee cannot take transferor's place without consent of all partners. Black small square no right to get information. Black small square no right to inspect partners' books. Black small square no distribution. Black small square no financial interest if partnership dissolves separate creditors' rights. One partner's creditors may obtain charging order on partner's interest in partnership and can force foreclosure which may dissolve a partnership at will, if term has passed or objective was met. Rupa SS 801, O dual priorities jingle rule as to partnership assets, UPA SS 40, H, gives priority partnership creditors over separate creditors as to partners' individual assets. Separate creditors have priority over partnership creditors. O the dual priorities jingle rule which was replaced by Rupa O preempted by CH7 of Bankruptcy Code. 11 USC 723, C, on page 60, in partnership bankruptcy, PC have priority over PP debts to PC remain unpaid after PS assets are exhausted. PS creditor. All put on parity with separate creditors in dividing up partnership and individual assets. Notes on partnership interests, 59. 7. The partner's duty of loyalty, 61. Meinhard v. Salmon, 61. NYC property leased 20 years, then new lease arrangement covenants met and an option to extend was taken up by the managing partner for his own benefit without his co-adventurer. Plaintiff prevails in report of referee, but Cardoso modifies at New York Court of Appeals in 1928 holding that conscious purpose to defraud partner by taking business opportunity for himself was a breach of duty to inform his partner and it was wrongful to act as a competitor when the partners are co-adventurers. The partners owe each other the highest duty of honor. Inia v. Superior Court, 66. 16. A partner in partnership owning an office building sued the other partners for renting the building to themselves at less than market value. The action was to dissolve and pay for deprivation of profits. The plaintiff prevailed because defendants' conduct violated their duties as partners per the common law definition which applies to CA, Corp Code Sect. 16404, BC. Partnership is a fiduciary relationship and partners may not take advantage for themselves at the expense of the partnership, which is interpreted to be explicitly exclusive enumeration of a partner's duties. Partner owes fiduciary duty of loyalty and care. Self-dealing is included in set of duties partners owe one another. Robert W. Hillman, Donald J. Widener and Alan G. Don the Revised Uniform Partnership Act, Section 404, at 381 to 386, 70. Partner self-interest per SS 404 of RUPA O narrowly means that partner can get incidental benefit if it doesn't deprive other partners, i.e., violate/offend non-fiduciary obligation of good faith or fair dealing. Not held to trustee duty O broad, academic, interpretation. Public policy wild not prefer overly broad statement of fiduciary duty to invite wasteful, costly threats of litigation. Notes on suits by a partner against a partnership, 71. XS O. Dissolution. O. Accounting. Black small square wrongfully excluded. Black small square appropriate unauthorized Ben A. Black small square just and reasonable. Black small square mistrust UPA SS 13 greatly limited, to exception. O. Were any wrongful conduct or omission of any partner acting in the ordinary course of business of the partnership or within the authority of his co-partner status, and loss or injury is caused to any person, not being a partner in the partnership. The partnership is liable therefore O exception S, when partner can bring action included. Black small square breach of partnership agreement. 17. Black small square wrongful dissolution. Black small square fraudulent breach of trust. Black small square misappropriation. Rupa SS 305 is the same, but removes the bracketed sections of UPA SS 13. 8. Dissolution. A dissolution by rightful election, 72. UPA SS 29-31, 1, 38, 1, 240. Rupa SS 601-3, 701, 801-2, 804, 807. Gerard Bank v. Haley, 72. Chancellor gave effect to partner's letter to terminate a partnership consisting of 5 total partners prior to the letter being tendered, but the appeal court reversed the termination as unjustified as per rule, page 72, UPA SS 31. Dissolution of partnership is caused by express will of any partner and need not be supported by justification, when a partnership is at will. But if the partnership results in breach of contract, then the aggrieved partners may recover damages for breach. The alternative to at-will partnership is a partnership that affixes a definite term or its general purpose is for a particular undertaking that is not fulfilled. DeSoto v. Stiltner, 73. Stilter buys out DeSoto's partnership interest in event of disagreement over choice to partition after third-party credit relationship ended. Applicable rule, absent other manifest intent. The rule favors liquidation, but doesn't compel liquidation absolutely by buyout. McCormick v. Abrevig, 74. Sister and farm ranch partnership sought an accounting and dissolution, and brother who alleged he would have received the partnership property as trust beneficiary if trust had been validly formed, brought fraud and negligence misrepresentation claim against sister and professional negligence claims against accountants. Cross appeals were taken from the DC's grant of partial summary judgment for accountants and sister. The special master ordered buyout, but sister rejected both 800K and 1M valuations, being of the opinion that she is entitled to more money that would result from an ordered sale of the partnership. On appeal, the court decides that the business must be liquidated per UPA. 18. And MCA state statute, because facts show a buyout is contemplated in event of partner's death. And the analysis insists a court can only order to dissolve, liquidate as strictly interpreted in partnership agreement documents. Notes on distributions in dissolution and services partners, 78. Note on joint ventures, 79. Page v. Page 80. The trial court rules in favor of dissolution of linen business that just passed equilibrium, finding it is an oral partnership for a particular purpose, objective to pay off debt and be profitable. Appeal court reversed and remanded to the lower court to evaluate if partnership is at will and use definition of wrongful dissolution to decide intent of partner that wants to dissolve. Wrongful dissolution. In a partnership at will, the dissolving partner has the power to dissolve the partnership by express notice to opposed partner. If, however, it is proved that dissolving partner acted in bad faith and violated his fiduciary duties by attempting to appropriate to his own use the new prosperity of the partnership without adequate compensation to his copartner, the dissolution would be wrongful and the dissolving partner would be liable. Notes on partnership breakup under the UPA, 83. Wrongful dissolution. O Phase 1, legal status. Dissolution ends going concern, but starts when declared by judgment to wind down. O Phase 2, termination. Black small square payoff creditors. Black small square settle accounts. O Phase 3, termination, UPA SS31 when partner withdraws it leads to a partnership dissolution even if contrary partnership continuation agreement, page 85, RUPA SS602, A. There is differing treatment for disassociation, right/power, rightful/wrongful. Wrongful disassociation creates liability to other partners. Black small square i.e. breach of partnership agreement. Black small square duty to cure. ORUPA system. 19. Black small square disassociation of partner doesn't require a dissolution if within 90 days of death or wrongful disassociation partnership decides between Art 7, mandatory buyout. Court may allow deferred payment if undue hardship. Payout reduced by damages if caused by wrongful disassociation of partner, i.e. for disassociation occurred before end of definite term or particular undertaking. Art 8, winding up, SS 801, dissolution is required otherwise Article 7 is acceptable. O1 partner expression to withdraw in partnership at will. O1 partner expression to withdraw at expiry of partnership term and uncured event, X in SS 801. That makes it unlawful to continue. SS 801 continues two concepts from UPA 01. Any partner of at-will partnership may force liquidation. By negative implication, partnership for term may not be forced to liquidate if against will of remaining partners. Notes on partnership breakup under RUPA 86. Corrales v. Corrales 88. Partnership purpose to repair, refurbish, and sell computer tape drives. Partners at dispute trial court applies SS 701 to value for buyout. Appellate division admonishes all parties, because SS 801 applies because the entity is a partnership at will. Article 807 commands that the partnership must be wound up, with creditors being paid with such adjustment to the individual partners' accounts as necessary after paying each creditor. 9. Dissolution. 2. Dissolution by judicial decree and wrongful. Dissolution, 89. UPA SS 31, 2, 32, 38, 2, RUPA SS 601-3, 701, 801-2, 804, 807. Congel v. Malfitano, 89. Facts. 20. In 1985, 7 partners formed Poughkeepsie Galleria Co. and agreed to term strategy in term CL of partnership agreement. On November 24, 06, after negotiations between partners failed, the DEF sent letter of election to terminate and force dissolution. PLs racked up $2,717,314 in attorney fees to avoid dissolution and $79,705 in expert fees. Procedural context. In 2007, the trial court made declaratory judgment that partnership was at will. SS 63 doesn't apply and partner liable for wrongful dissolution. In 2009, appeal court upheld that Partners Act was wrongful on different grounds and remanded to the SC, which held partnership by particular undertaking, and an appeal court which held partnership for specific term. In 2011, the SC awarded attorney fees and expert fees that were not incidental damages and reduced goodwill interest, which yields partners interest at 4.85 m. Holding. 1. The dissolution was wrongful based on deviation from term agreement, not because it is specified term or particular undertaking. 2. Goodwill deduction is appropriate based on factual support. 3. Attorney fees are incidental, not a result of DEF's Act per AC. 4. Propriety of minority discount is implicit in rule on buyout valuation. Note on wrongful dissolution, 94. Great consequences for wrongful dissolution as violation of PSAG, such to dissuade partner from exercising a self-help election and guessing wrong. Note on the expulsion of a partner, 95. UPA doesn't prevent a partnership agreement from providing terms to expel a partner W/out cause by majority/designated vote by remaining partners. However, if in bad faith/predatory purpose SS 31, 1, D. Would treat it as violation of partnership agreement that gives rise to action for damages UPA SS 31, 1, D, 32, 1, D. O. Expulsion of partner without good cause prior to end of partnership term is ordinarily wrongful violation of partnership agreement, and wrongfully expelled partner ordinarily has right to have partnership dissolved or liquidated UPA 38, L. 21. O. If dissolution is caused by the expulsion of a partner that is bona fide under the partnership agreement and paid net interest, liabilities, it is not at violation/entitlement to damages. Note case, Nozzle. O. Partner expelled of Winston and Strawn on Nozzle's request for partnership info because he was suspicious of managing partner acts surrounding raising combination and O.
So we're about a quarter of the way done at 45 minutes. So this is going to be up to 3 hours of recording.
And ownership interests of committee members. On seeking a declaratory judgment, the summary judgment was rendered for WNS. The appeal court reversed, because expulsion was per facts retaliatory for inquiring about sensitive materials for which Nozzle and all partners are entitled by Partnership AG. And Code. Displacement ungrounded in light of recent performance appraisal assuring greater compensation and assurance that Nozzle would not be displaced. Question whether vote on raising compensation was conducted or managing partner, Fairchild, who had motive to be secretive based on billing fraud in internal control report, requested by Nozzle and identified after suit. Overall, expulsion void of good faith and honesty. The facts constitute a breach of partnership agreement and act. 10. Limited partnerships, 97. Statutorily created RULPA, 1976, adopted in 21 states. Modernizes ULPA of 1916, accepted in 49 states, SS 101, a partnership formed by two or more persons under the laws of this state and having one or more general partners and one or more limited partners, SS 201. Requires certification of limited partnership to be filed with Secretary of State, which contains O name of LP, O name and business address of each general partners, GP. O latest date in which partnership is to dissolve, O name and address of agent for service of process. A. The Uniform Limited Partnership Acts, 97. B. A formation of limited partnerships, 98. O. RULPA SS 101, 201 O ULPA SS 101, 201 of 2001. C. Liability of limited partners, 98. 22. O. RULPA SS 303 O ULPA SS 303 of 2001. Gateway Potato Sales v. GB Investment Company, 99. PL is a creditor of Sunworth Packing LP that supplied substantial quantity of potatoes from February 86 April 86. DEF is a limited partner of Sunworth Packing LP along with Sunworth Corp, the GP of the LP. Trial court granted LP's motion for summary judgment on the question whether GB exerted control over the LP. However, the appeal court reversed and remanded, because there was probable issue of fact that LP exerted control, viewing in the light most favorable to the appellant to withstand pleadings. The AC underwent the legislative analysis of the rule that creates liability on LP if third party had knowledge of him, even if no direct dealings, basic test, to determine that basic test from the 1976 rule still applied in AZ, notwithstanding the substantially the same conduct as GP test of the 1986 rule revised, which was not made effective in AZ. D. Corporate General Partners, 105. Ordinarily, shareholders are not liable for their corporation's debts. Corporations may be a general partner of a limited partnership. Per both. RULPA and UPLA corporate directors and officers are not ordinarily liable for participating in control of limited partnership as general partner unless they O. Fail to maintain corporate identity, O. Conduct affairs through corporation, O. Intermingle assets, O. Insufficient capitalization of corporation. Note on corporate general partners, 105. In Re USA Cafes, LP litigation, 105. Facts: alleged breach of duty of loyalty by class action, consisting of limited partnership shareholders against limited partner, general partner, individuals who collectively own 100% of the general partnership and 47% of the limited partnership, and 4 other boards of directors of general partnership for the receipt of personal benefit monies and loan forgiveness. Defendants were denied motion to dismiss. Argument arises because Metza Ac. Group purchased USA 23 Cafes LP on 10/1989. Acquisition of limited partner. In 1989, the limited partnership was formed as part of a Red Grant organization. USA Cafes Incorporated, a Nevada corporation, as well as USA Cafes General Partner Inc., a Delaware corporation. The minority shareholders were paid inadequate price per share unit because the controlling majority obtained significant cash payments or loan forgiveness resulting from the acquisition. The question presented is whether a general partnership owes duty to a limited partnership it controls. Rule: the court applies the definition of fiduciary duty on page 107. To corporate trustees, the law of trust represents the earliest and fullest expression of this principle in our law. But courts of equity have extended it appropriately to achieve substantial justice in a wide array of situations. Thus, corporate directors, even though not strictly trustees, were early on regarded as fiduciaries for corporate stockholders, when control over corporate property was reorganized to be in the hands of shareholders who controlled the enterprise. The fiduciary obligation was found to extend to such persons as well. Holding: general partner directors a duty to limited partnership even if corporate general partner serves as a limited partner by a way of trust. Principle. Applicability. E. The taxation of unincorporated business organizations, 109. Firm taxation. O. Business responsible for tax on income. Business makes distributions to owners from after-tax income. Double taxation, flow-through taxation. O. Income and expenses. Profit and loss flow through to business owners and taxes are paid once therefrom open, or losses offset income from other sources. O. Individual owners pay individual tax on distribution. S Corp. O. Subchapter S of IRS Code Section 1361 through 1369. O. Pass through by pro rata. Black small square if limited to individual/trust. Black small square only one class of stock. Black small square less than 100 shareholders. Master LP. 24. Black small square limited partnership with limited partnership interests are publicly traded. 2017 Omnibus Tax Act reduces corporate tax rate 2 to 21%. Gives 20% deduction on qualified business income, except for law firms and medical practices. F. Fiduciary obligations of limited partners and the obligation of good faith, 111. Diekman v. Regency GPLP, 111. Court of Chancery grants defendant motion to dismiss because duty was contracted away and adherence to rules over restructuring decisions. Reversed on appeal because his limited partnership agreement is stricter than what rule requires and rule applies. Rule: Drupla gives maximum effect to the freedom of contract. Holding: Therefore safe harbor would be given effect. However, here the conflict of interest in the Conflicts Committee, which undermines the intent of SEC laws. Brinkerhoff v. Enbridge Energy Company, 116. Plaintiff brings cause of action alleging defendants breached limited partnership agreement by agreeing to repurchase the same asset on terms that are not fair and reasonable. Defendant is a master limited partnership defined as a family of entities that often engage in internal business transactions, referred to as drop-downs, roll-ups, insider financings, incentive distribution rights, and equity investments. Limited partnership agreement excused fiduciary duty as long as not in bad faith. Pleadings sufficient to meet inference of bad faith defined in Delaware as DEFS did not reasonably believe it was acting in the best interest of the partnership. Reverse motion to dismiss, because plaintiff met burden. Remand with instructions that drafter cannot disclaim the implied covenant of good faith and fair dealing. Good faith is defined in contract as a standard of care that the GP reasonably believe that its action is in the best interest of or not inconsistent with the best interests of the partnership. 11. Limited liability partnerships, 121. 25. Rupa SS 102, 9, 306, C, 901 Limited Liability Partnership, LLP, O General Partnership, but liability of GP in LLP is less extensive. 10. The liability of a GP and LLPs must be registered with the appropriate state office. Every state has adopted some LLP statutes. Limited liability, limited partnership, LLLP. Liability of GP in a limited partnership is limited. Note on limited liability partnerships, 121. Bromberg and Ripstein, Limited Liability Partnerships, the Revised Uniform Partnership Act, and the Uniform Limited Partnership Act, 122. OLLP statutes may eliminate partners' vicarious liability for all types of claims, or at least up to their investment. Note on liability for involvement, 123. In a professional LLP, when more than one partner was involved with a decision, the level of involvement will subject a partner to liability for Re's own conduct if the decision is later attacked. Chapter 3. The Foundations of a Corporation. 1. Characteristics. Shareholders, owners, not personally liable. Managers are not personally liable, unlike general partners. Free transferability of ownership. Not in small corporations. Continuity of existence. Centralized management. Entity status. Civil rights. Example, free speech. 1. Architecture. State statutes. State case law. 26. Federal law. Soft law, stock exchange rules, etc. State of incorporation governs the corporation's internal affairs. States try to regulate foreign corporations from other states doing business in their state. 1. State of organization. Tax reasons to keep small companies local. Race to the Bottom, an influential 1974 article about evolving state corporations law. Delaware law gives managers more power compared to shareholders in other jurisdictions. Delaware has a well-educated judiciary and elite local counsel. Like Microsoft Office, Delaware corporate law is used generally, so even if it is difficult or annoying, it is important. 1. Formation formalities matter. Authorized versus issued stock. Classes of stock either in the certificate or empower the board of directors to establish. Staggered. 1. Raising capital / financial instruments and securities. Common stock. Preferred stock, paid out before common stock at liquidation. Debt. Bonds. Debt holders have a fixed claim, shareholders don't. A. Trade debt. B. Bank debt. C. Bonds. D. Debentures. E. Notes. F. Interest can be deducted by a corporation, but dividend payments cannot be deducted. Equitable subordination of shareholder claims. Equitable subordination and piercing the corporate veil, often caused by undercapitalization. Uniform Fraudulent Transfer Act and parallel sections of the Bankruptcy Code. More on formalities. 27. Plenty of cases about bad faith. Short notice of meetings, unreasonable restrictions on discussion in board meetings. These practices can be inappropriate even if not in bad faith. Why have a formal meeting if everybody agrees? Jurisdictions differ. Chapter 3. The Foundations of a Corporation, 125. 1. The characteristics of a corporation, 125. Corporation O is a legal person or legal entity O separate from its owners, shareholders, O formed by filing instrument, certificate of incorporation, articles of incorporation or a charter, O characterized by black small square limited liability, shareholders have limited liability. Managers are normally not personally liable for corporate obligations as long as managers act on the corporation's behalf and within their authority they are treated like agents, not principals for liability purposes. Black small square free transferability of ownership interests. Black small square continuity of existence. Black small square centralized management. Black small square entity status. Black small square the right to own property. Black small square the right to make contracts. Black small square the power to sue and be sued. Conflicts of interest O traditional conflicts, i.e. self-interested transactions O positional conflicts by managers to maintain or enhance their positions. Black small square governance state statutory law. State of incorporation dictates choice of law. However, New York and CA have adopted provisions in 28. Their corporate statutes under which designated sections apply to the internal affairs of certain corps incorporated in another state judge-made law federal law soft law O securities acts and Sarbanes-Oxley O private ordering, stock exchange rules. 2. The architecture of corporate law, 126. See governance above. 3. Which state's law governs a corporation's internal affairs, 127. Vantage Point Venture Partners 1996 v. Examen Incorporated, 128. Cause of action involving a merger was taken up in Delaware, State of Incorporation, and California pursuant to Section 2115 of the California Corporations Code applies to corporations that have contacts with the state but are incorporated in other states. The D Court of Chancery's holding that DE law applies to the merger voting was affirmed in SC of DE, which rejects the internal affairs doctrine, is a long-standing choice of law principle which recognizes that only one state should have the authority to regulate a corporation's internal affairs, the state of incorporation, which is supported by public policy's preference for consistency and restatement. Second of conflict of laws SS number 301, application of the local law of the state of incorporation will usually be supported by those choice of law factors favoring the need of the interstate and international systems, certainly, predictability, and uniformity in result. Protection of the justified expectations of the parties and ease in application of the law. To be applied, and the Commerce Clause, a state has no interest in regulating the internal affairs of foreign corporations, and public policy discouragement of forum shopping. 4. Selecting a state of incorporation, 135. New York Bus Corporation Law SS 1371, 1318, 1319, 1320. If a corp has only a few owners, it will usually be incorporated locally. O. States impose a doing business tax on the corp on a basis that reflects the amount of that business. 29. The favorability of one state's statutes toward corporations has come to be known as the market for corporate charters. Black small square opposite, suboptimal legal regime. Black small square relevant for agency cost theory. Black small square relevant for protections against conflict of interest transactions rules surrounding friendly acquisitions market price of the shares successful hostile takeover investment banker fees legal fees. Black small square is there a premium value benefit of being incorporated in Delaware skilled bar high quality corporate counsel network externality. 5. Organizing a corporation, 142. Del.gen.corp.law SS 109 Model Bus. Corp. ACT SS 2.06, October 20th. 21 Preliminary Incorporators/Promoters Subscription Agreement Pre-Incorporation Subscriptions. Black small square old rule. Pre-incorp subscription was only a continuing offer by the subscriber and that a subscriber therefore was not bound if he timely revoked. Carry right to revoke until incorporation. Black small square viewed as mutual promises of subscribers as consideration for each other implementation. O file a certificate of incorporation in a designated office. The state O issue stock. Black small square series common preferred. 30. O liquidation order. O dividend paying authorized issued and outstanding treasury stock. O authorized and issued, but not outstanding preemptive right at common law. Existing shareholders had the right to subscribe a proportionate part of a new issue. O incorporators have powers of directors until their elected. O incorporators typically adopt bylaws and elect initial directors at first annual meeting of shareholders. Delegate General Corporation Law SS 107, 108. O organization meeting. O form of minutes of organization meetings. O 6. The basic types of financial securities. 144. Corporate capital structure. O common stock. Black small square equity interest. Black small square right to vote in the election of directors and certain other matters. Senior claimants. O preferred stock. Black small square contingent. No promise of repayment of original investment only. Black small square cumulative / non-cumulative. Concern dividend distributions first, going to holders before common. Black small square no obligation to repay at fixed rate. Black small square straight preferred stock, most frequent type. O debt, fixed claim against the corp for principal and interest. Black small square trade debt. In bus purchase of goods or services, a payment is typically not due for 30, 60, or 90 days. Termed accounts payable. Black small square bank debt, financing from commercial bank loans. Termed loans payable. Black small square bonds and debentures. 31. O promise to pay. O by borrower. O of specified amount. O on specified date. O together with interest. O at specified times. O on the terms. O and subject to the conditions. O spelled out in the governing indenture. O usually less than 10 years. O termed bonds payable. Indenture is a debenture of a longer term, usually greater than 10 years. OK entered into between borrowing corp and trustee. O trustee admins payments of int and principal. O monitors and enforces compliance. Black small square constrain the unilateral enforcement rights of small holders. Black small square channeling enforcement through central agency of trustee. O bundle of additional promises. O bondholders are third-party benes of promises. Senior debentures normally represent money borrowed from the public or at least from a significant group of lenders or investors. Convertibles, classified stock, and derivatives. O many preferred stocks and some bonds are made convertible into common stock at the option of the holder on specified terms. O right / warrant issued by the corp that gives the holder a right or option to purchase common stock on specified terms. Introduction to types of debt and debt covenants. 147. 7. The seductive qualities of debt. 149. John D. Eyre, Guide to Finance for Lawyers, 295 to 297, 149. Arbitrage optimal debt equity ratio. 32. Irrelevance theorem page 152. Note on the tax shield of debt. 151. Interest is a deductible expense. Dividends are not. Multifaceted Tax Act of 2017 limits the amount a corp is entitled to deduct as busint. Per year EBITDA, earnings before income taxes, depreciation or amortization. EBIT, earnings before income tax. Note on leverage and the risk of financial distress. 153. Equity-based firms in bankruptcy are more attractive to an investor than debt-based companies. Inverse relationship between debt and penalty. 8. Equitable subordination of shareholder claims. 154. Uniform Fraudulent Transfer Act SS4 Bankruptcy Code $548. A transfer is constructively fraudulent and therefore can be set aside and recovered by the bankruptcy trustee when the debtor, within 2 years before the BK filing, makes a transfer of assets either insolvent or with an unreasonably small capital and receives less than a reasonably equivalent value in exchange for the transfer. Disguising equity as a loan. Note on equitable subordination of shareholder claims, 154. Seminal case Taylor v. Standard Gas and Electric Company, 1939. O founded deep rock doctrine of equitable subordination. O improper capitalization led the court, in that case, subordinated the parent's claim as a creditor of the subsidiary. O principles analysis. Black small square 1. Inequitable conduct directed against the bankrupt or its creditors may be sufficient to warrant subordination irrespective of the cause. Black small square 2. Claims should be subordinated only to the extent necessary to offset the harm creditors suffered from inequitable conduct. Black small square 3. Allocation of the burden of proof, substantial factual basis. 33. Made by claimant obliges objecting trustee to come forward with enough substantiations to overcome the claimant's prima facie case. Gannett Company v. Larry, 155. Held, it would be unfair to allow the claim of Gannett on a parity with other creditors who lacked the interest which Gannett had in Berwyn's disastrous experiment, capriciously buying competitor and using it for upstream supply chain. Newsprint field. In such circumstances, proof of fraud or illegality is not necessary. Rule derives from seminal case Taylor v. Steinhard Gas and Electric Co. when the court subordinates the parent's claim as a creditor of subsidiary. BOP for impropriety. 1. Inequitable conduct. 2. Offset to extent it addresses harm. 3. BOP prima facie by complainant. Note on equitable subordination versus piercing the veil, 156. Burden higher for protection of shareholder whose risk is limited to amount of his investment. Note on characterization of promoter's advances, 156. Promoter founder case note, in Arnold v. Phillips, Arnold infused business with capital twice. First was an initial capital contributions of 50G then 75G when the business was in trouble that was characterized as a loan. The court made a debt equity distinction that subsequent advances made after the brewery became a going concern should be valid debt, because otherwise would discourage GF loans, i.e., where the trustee proves that the loans were made when no other disinterested lender would have extended credit. 9. Requisites for valid action by the board, 158. del.gen.corp.law SS 141, B, F, I, 229 Model Bus. Corp. Act SS 8.22-24. 34. Fogel v. U.S. Energy Systems Incorporated, 158. 3 directors secretly agreed to oust Fogel, CEO/chairman. They deceived him to attend a meeting on other pretenses, where they demanded his resignation. He refused to provide it that evening, June 30th, 07. Fogel attended meeting next day to call for a special meeting to vote on removal of 3 non-officer directors. The termination was ratified on that day. The court held that Fogel had authority to call a special meeting, because his resignation/termination was not official, without meeting notice/formalities, and therefore ratification invalid. The rule applied is that void actions cannot be ratified. Fogel was entitled to hold special meeting. Notes on requisites for valid action by the board, 162. Formalities. O notice. Black small square not required if meeting is regularly scheduled. Black small square every directory to be apprised of date, time, place. Black small square notice can be waived. O quorum. Black small square majority of authorized number of directors. Black small square majority of directors then in office. Black small square substantial majority. Black small square statutes permit certificate of incorporation/bylaws to require more than a majority of voting. Black small square most statutes provide that articles or bylaws can require a supermajority vote for board action non-compliance. O cure deficient notice. O lack of quorum or required affirmative vote will render board action ineffective. 35. O case note, Gerard v. Empire Square Realty Co. Court held formalities may be overcome if all directors consent. While there was no SH or directors meeting held, each director separately agreed to hire plaintiff. Valid hire. O analysis fact-based. Black small square acquiesce, no action to disavow. Black small square shareholders have acquiesced if they tolerate informal manner of directors' meetings for a period of time. Note case Clausen v. Allegro Dev Corp. follows on Fogel case. Clausen deceived about nature of meeting, but that deception was not interference with what's required to constitute a meeting. Because the meeting was regularly scheduled, no notice is required. Note on board committees, 165. Audit Committee, Compensation Committee, Nominating Committee, Corporate Governance Committee. 10. The normal requisites for valid shareholder action, 165. Del.gen.corp.law SS 211, 213, 214, 216, 222, 228 model.bus.corp.act SS 7.01 to 7, 7.21, 7.25-8. Gwynar Hartman Revocable Living Trust v. S. Michigan Bancorp. Inc. 165. Trial court dismissed cause of action number 1, wherein the trust objected that Bancorp didn't give any disclosure in agenda for shareholder meeting about shareholder proposed edit to bylaws. In second COA, trust objected to disclosure giving short shrift to shareholder proposed edit to bylaw. The court dismissed the first action and on appeal, considering the second action, it reviewed Bourne v. Sanford to interpret the purpose notice requirement rule in reference to shareholder meeting proposal to dissolve a company and held the principle applied notwithstanding great difference in purpose offered up for shareholder vote. Notes on the normal requisites for valid shareholder action, 167. 36. Most statutes require notice requirements to describe matters for vote amendments. Sale of assets proxy rules do not apply to all core. Record date stands for when stock transfer books are closed before shareholder meeting, and record holders on the date will be given notice of SH meeting. GCL SS 707 allows 2 separate record dates. O. Who can attend. O. Who can vote. Fundamental changes. O. Amend certifying. O. Merger. O. Sale of substantially all assets. O. Dissolution rule of convenes. O. Written consent. Acceptable remote participation in digital meetings require full auxiliary, read, hear, voting capabilities. Espinosa v. Zuckerberg, 169. Shareholders allege wasteful awards, self-dealing, and breach of directors' fiduciary duties in the BOD approval of substantial stock options for its non-executive directors. Decision protected by highly deferential bus judgment rule that Zuckerberg gave credence by way of ratification embedded in affidavit filed with MSJ that he as majority shareholder would have voted in favor of the compensation package as justified for talent retention. If it was presented for his vote, he would sign a written consent. However, he never signed a written consent because that would trigger a rule of disclosure. Rule 8 del C SS 228 triggers obligation to notify non-consenting stockholders of the action taken. Holding, action ratified, no requirement triggered, and bus judgment rule shields. 11. The election of directors, 171. Staggered boards, 171. A board divided into 2 or more classes, each of which is elected separately for staggered terms. 37. To ensure continuity to deter prospective bidders from making a takeover bid in conjunction with poison pill is the most powerful takeover defense available. Declassify, destagger, to eliminate a staggered board. B. Cumulative voting, 172. A shareholder can distribute among her nominees, in any way she pleases, a number of votes equal to the number of her shares times the number of directors to be elected. O. Equation to determine number of shares needed to elect a particular number of directors equals 1 plus S asterisk N slash D plus 1. O. Equation to determine how many directors can be elected by a group controlling a particular number of shares traditional straight voting shareholder can cast for each open directorship. A number of votes equal to the number of her shares. Some statutes may prohibit staggered board and cumulative OIL prohibited. OAZ, OK when there is 9 BODs, ODE, Craigslist director with 28% sold Craigslist shares to eBay and eBay rep took his directorship. 72% directors amendment to certificate of incorporation electing staggered board, 1 out of 3 each year, was valid. eBay was not deprived of anything as the company is entitled by common law. And DGCL to a staggered board. The amendment cannot be subjected to entire fairness review on the grounds that eliminating eBay's ability to elect a director was a form of self-dealing. See a plurality voting, 176. Nominees who received the most votes were elected even if none of them has a majority election by at least one affirmative vote, even if the majority of votes are withheld. Brynard Voller, majority election of directors, where are we today? 176. Intel amended bylaw requiring election of directors by majority and has become the gold standard majority election by majority vote standard, instead of just a resignation policy. 38. Holdover rule. An incumbent nominee who fails to get the required vote remains in place under the so-called holdover rule, i.e. directors remain in place until their successor is elected and qualified. Lessens director changeout without shareholder consent, i.e. unintended consequence of Operation Board adopted governance principle. Model Act 2006 amendments permits bylaws to limit term to 90 days for a director nominee in uncontested election that received more votes withheld. Then in favor DGCL 2006 amendment allows bylaw to require nominee director to resign. Election results could not be rescinded or modified by the board to affirm the validating. Note on trend in plurality versus majority voting, 178. Plurality was an outlier, but is expected to become universal. DA proxy access, 178. Bylaw procedures allow shareholders to nominate individuals to stand for election to the board without incurring the expense of undertaking a proxy solicitation. Short slates, 178. Shareholder proposed slate of candidates for less than all and usually less than a majority of the directors to be elected avoids triggering a change in control provision avoids triggering poison puts provisions in a company's debt instruments that require the company to repurchase outstanding debt obligations upon the occurrence of certain defined events. 12. Removal of directors, 179. del.gen.corp.law SS 141, K. In Revalco Energy Shareholder Litig. 179. Notes on the removal of directors, 180. Shareholders can remove a director for cause even in the absence of a statute that so provides. 39. Shareholders cannot remove a director without cause in the absence of specific authority. Cal.Corp Code SS 303. A. Model-Bus.Corp Act SS 8.080A certificate or bylaw provision may not authorize the removal without cause of directors elected after the provision has been adopted in absence of statute. The board cannot remove a director either with or without cause. OCA. Other statutes permit removal for felony. ONJ. Permit removal according to Certificate of Incorporation. Courts have the power to remove directors. 13. The Classical Ultra Vires Doctrine, 181. DGCL SS 101, B-102, A3, 121, 122, 124. Introductory Note, 181. Corp regarded as fictitious person endowed with life and capacity only insofar as provided in its charter. Early corp charters narrowly circumscribed the sphere of activities in which a corporation would engage. Transactions outside that sphere were beyond the corp's power and unenforceable by or against the corp on grounds the transaction lacked mutuality. Seminal case Ashbury Railway Carriage and Iron Company v. Riche, 1875. Riche sued to recover railway construction costs when Ashbury repudiated, but court held for Ashbury because it lacked the power under its charter to build a railroad and therefore lacked the power to contract for that purpose. Legislative intent is to protect the public or the state from unsanctioned corporate activity. Analysis. First, whether a corp had acted beyond its purposes/engaged in type of business activity not permitted under its certificate. Whether the corp had exercised a power to specified in its certificate. Unsound doctrine of steady erosion. 1896 Sutton's Hospital case. Courts liberal in finding implied powers to enter into business activities not specified in certificate, not a defense to corporate tort, not a den fees to criminal activity. Executory contract applicability. If corp received a benefit under the contract, it was stopped from asserting an ultra vires defense. 14. The objective and conduct of the corporation. 183. A. The maximization of shareholder wealth. 184. Henry Hu, New Financial Products, The Modern Process of Financial Innovation, and the Puzzle of Shareholder Welfare. 184. Corp purpose pecuniary benefit of shareholders with less regard for notions of social responsibility. Maximizing earnings. Corporate investments. Dividend policy. Time value of money. Traditional conception. Welfare of corp is coincident with the welfare of its shareholder. Competing conception. Pecuniary goals of a corp is directly focused on the welfare of the shareholder. Achieved through combination of maximizing the actual short or long-term trading price of each share of common stock and the dividends they actually receive. B. Interests other than maximization of shareholders' wealth. 185. Note on Dodge v. Ford Motor Company. 185. Minority shareholder investors sue Ford over new policy to reinvest and pay no future dividends on retained surplus of profits. Rule: IRS will penalize co-holding too much retained surplus of income. Court required the company to pay dividends to its shareholders against the company's newly established eleemosynary policy. Note on maximizing for the long term versus the short term. 188. Activist investors owe fiduciary relationship requires that directors act prudently, loyally, and in good faith to maximize corp value over the long term for its stockholders' benefit. 41. Shortism, long-term gains have a greater present worth than the risk-adjusted short-term strategy. Risk aversion and risk-seeking behavior. Example: management's broad discretion within LTV. ST debate is actually an embrace of an objective of corp sustainability and not wealth maximization. Shareholder primacy model. Dodge directory primacy. Note on other constituencies under Delaware law. 190. Other constituents. Creditors. Customers. Employees. Community. Trilogy about whether announcing changes to policy and bylaws, articles of incorporation to avoid takeover is valid. Unocal v. Mesa Petroleum Co. 1985. Great management deference as long as some benefit to shareholders. Paramount Communications Incorporated v. Time Incorporated. 1989. Corporate policy protects culture interests. eBay Domestic Holdings v. Newmark. 2010. Facts do not show Craigslist as a culture interest. To be protected. Other constituency statutes. 193. Consider INTs of corp and effects upon employees, suppliers, customers, subsidiaries, communities, IL Comp, Stat and P. 194. Factors. Whether the auth to consider constituencies other than shareholders is limited to takeover context. Whether consideration of other constituencies is discretionary or mandatory. Whether all constituencies are to be considered in equal weight. Whether the auth is set forth in the corp statute and hence available to all incorporate firms or is permitted to be included in the AOI if the corp so chooses. Milton Friedman. The social responsibility of business is to increase its profits. 194. 42. Objective. Make as much money as possible while conforming to the basic rules of society. Objective. Eleemosynary purpose. Ex hospital, school, etc. Oliver Hart and Luigi Zingals. Companies should maximize shareholder welfare, not market value. 195. Opposes Friendman's position O separability assumption O inextricably connected O form premise of corporate social responsibility O takes social factors into account and internalize externalities in their own behavior. Note on benefit and flexible purpose corporations, 196. Benefit Corps AOI, while not strictly nonprofit, commit corp to provide benefit to gen public environment hybrid between for-profit and not-for-profit benefit corporation statutes, New York, MD, DE, PACA. VANJ Model Benefit Corporation Legislation SS 201 General Public Benefit, Material Positive Impact on Society and the Environment are in the best interest of the Corp XS, provided page 196 shall consider externalities and have no obligation to give priority to any person, group, or objective, ca. AP Smith Manufacturing Company v. Barlow, 197. Ultra vires subordinated by statutes apply retroactively to pre-existing corporate charters void of a purpose to provide charitable donation. NJ Pipe Manufacturing Company, organized in 1896, didn't include intent to make charitable donations in its orging documents, purpose and powers. The company made a few small donations to colleges, rationalizing that college produced their administrative workforce, and private schools devoid of governmental support are a fixture to sustain free thought and democracy. 43. Rule that between 1930 and 1950 statutes that allow inherent power to make donations to the benefit of the community can retroactively applied and only requires the donation is in a reasonable amount and a nexus with corporate interest. Notes on the conduct of the corporation, 202. DGCL SS 122, 9, 12, Model Bus Corp Act SS 3.02, 12, 14, statutory provisions, donations should be reasonable. Direct corp benefit is no longer necessary, but corp int remains as motive boundaries of discretion. Median contribution was 1% of pre-tax income. Note on political contributions by corporations, 203. con.gen.stats.ann.ss33-756 ind ss 23-1-35-1 New York Bus Corp. Law SS 717 Pennsylvania Consol. Stats. ANN, Title 15, SS 1711, 1715, 1717, 2502 Tillman Act of 1907 barred corps from contributing to political campaigns or elections. But Citizens United v. Federal Election Commission, Clinton propaganda case, held that the corporation enjoys certain freedoms under the First Amendment. Chapter 4, The Legal Structure of Publicly Held Corporations. Melvin A. Eisenberg, The Structure of the Corporation 1, 205. Introductory Note, 205. 1. The legal distribution of power between the board and the shareholders, and equitable limits on the board's legal power, 206. 3. Board 4. CEO/executives 5. Shareholders takeover bid is an uneconomical way to oust ineffective management. O legal fees. O printing. O advertising. 44. O resistance raises costs. O stock price increases by 30%. Takeover management to outweigh detriment if they can increase the share price above 30%. A. The legal distribution of power between the board and the shareholders, 206. Charlestown Boot and Shoe Company v. Dunsmore, 207. Company founded in 1871. Elected directors Dunsmore and co-defendant Willard in 1873. Shareholders are displeased with the rector's management, formed a committee headed by Osgood to wind up the company, but the existing directors would not cooperate with Osgood and issued and squandered debt against assets, failed to maintain insurance on real property and equipment which was lost in a fire on April 28, 1878. Rule: directors are duly appointed by director or shareholder and put officers/agents to run the company within the constraints of the bylaws. Shareholders cannot appoint a peer officer or director or compel directors to act with one not duly appointed. No statute or legal requirement to hold insurance either holding. Demur by directors sustained on appeal. Appointment of Osgood was inoperative and void. Director is not liable to shareholders for failure to insure property because statute does not require they hold insurance. Franchise Services of North America v. United States, 208. Fees for advisory services incurred for company merger were paid by providing preferred golden shares to the advisory company that would be barred from bankruptcy proceedings that occurred without approval by preferred shareholders. After acquisition of voluntary bankruptcy petition for by the Board of Director rule that bankruptcy petition can only be made by the Board of Directors and not subject to be duly authorized by the shareholders. Additionally, corporate governance documents do not reserve veto power. The court held that the golden share provision was valid in Delaware. Turn light. The equitable limits on the board's legal powers, 209. Outcome agreed with 1967 article that power to board of directors are limited if used to the detriment of shareholders. Schnell v. Chris Craft Industries Incorporated, 209. 45. By law stipulates shareholder meetings and management on notice of October 16, 1971 meeting of shareholders to wage a proxy fight. Management responded by changing the bylaws at October 18th meeting to adopt new Delaware corporation law for changing dates and announced next shareholder meeting date of December 8th with purpose to obstruct/gain advantage in contest by reducing shareholder preparation time. Management refused to provide proxy solicitors' names and render list of shareholders while practice legally conformed to the rule. The court held that inequitable action does not become permissible assembly by legal possibility. The trial court denial for injunctive relief was reversed and remanded with instructions to reinstate the notice policy in the bylaws. A. Burley and G. means the modern corporation and private property, 211. Blasius Industries Incorporated v. Atlas Corporation, 211. Blasius is a venture capital firm that bought less than 10% shares and filed 13D with SEC in it proposing leveraged restructuring followed by written consent to the same coupled with revision to bylaws to increase BOD to 15 and elect 8 more. Atlas responded defensively and call the board to revise the number of directors and re-elect it to ahead of the next meeting. Defensive actions were set aside by the court because the Blasius proposal was not yet a threat requiring defensive action. To determine if defensive action fell within the deferential business judgment rule, there's a requirement to determine if the actions are honest in good faith with due care and competence. Determining the motive would be subject to per se invalidity, but the court instead fashions a standard of compelling justification which involves a subjective test to determine the primary purpose of management interference with corporate vote. Note on further proceedings in Blasius, 218. A disinterested director or officer will not be liable for the adverse consequences of a bad decision unless the decision was irrational. Court did not apply business judgment rule 2 analysis on the liberty of board of directors nominee as defensive action to shareholder proposal. Court applied standard of compelling justification, i.e. per se invalidity, to strike down inequity any board of director action taken for primary purpose of interfering with effectiveness of corporate vote, primary purpose determined by subjective test. Note on the business judgment rule, 219. C. The role of bylaws in the allocation of power between the 46. Board and the shareholders, 219. Certificate of Incorporation primary and overrules contradictory bylaws. Certificate of Incorporation primary. O expressed powers to corporate officers. Bylaws secondary. O time, O place, O manner, O quorum, O voting shareholder influence over bylaws. O shareholders and board of directors required to black small square adopt. Black small square amend. Black small square repeal bylaws. O advance notice is a standard fixture. Black small square bylaws may require shareholder to give advance notice, specified in days, to introduce business nominate directors at annual shareholder meeting. Black small square purpose. Orderly functioning preparation / inform shareholders defensive strategy for activist shareholders. Oh, note case. JANA Master Fund Limited v. CNET Networks Incorporated. Advance notice by law prevents shareholders with less than 1,000 shares for less than 1 year to propose / nominee directors at shareholder meeting by way of corporate proxy materials. Court allowed shareholder proposal if shareholders prepare proxy materials at its expense. CA Incorporated v. AFSM Employees Pension Plan, 221. Shareholders of CA Inc. proposed vote on adoption of VLAWs to provide for reimbursement and proxy expensive under specific circumstances, but the Articles of Incorporation / Certificate of Incorporation matches language in statutes. Del C. SS 141. The management of the business and the conduct of the affairs of the corporation shall be vested in the Board of Directors. SS 109. Shareholders have right to adopt from legislature. $141. Business and affairs best to Board of Directors. Unless otherwise limited by legislation or the Certificate of Incorporation. 47. Both the Board of Directors and shareholders wrote letters, including contrary legal opinions, for their positions to the SEC for no action letter. SEC files with Delaware Court for interpretation. Issue 1. What is the scope of shareholder power to adopt a bylaw about proxy reimbursement? Issue 2. Is proposed bylaw by shareholder fall within the scope permitted? Holding. For the shareholders to propose list by law, it would commit management to act which is contrary to Delaware corporation law. Shareholders must modify certificate of incorporation or seek recourse from Delaware General Assembly. 2. Corporate governance and the rise of institutional shareholders, 229. At shareholder voting, 229. Weighted voting proportionate to shareholders' equity interest in organization, O, can work as anti-takeover defense. O1 class has voting power out of all. Black small square dual class common. Black small square super voting stock. Note case, Stroh v. Blackhawk Holding Corp., 1971. Per Illinois law, management brought artificially low stock be authorized under Certificate of Incorporation because its voting weight gave them 28.78% control. Issuance was valid permitted under the law if within Certificate of Incorporation or Articles of Incorporation. Note case Williams v. Greer. DE upholds 10-year voting scheme. 10 votes / share reduced to 1 / share in change of ownership. Replenish at 3 years ownership. Snap Inc. Snapchat IPO had reserved super voting shares and public 1 vote, 1 share. Business Roundtable v. SEC. Court allow SEC to prohibit dual class share issuance has unless organized that way at IPO. Note on weighted voting in publicly held corporations, 229. Companies with time shared voting. I performed the S&P by 6 times during a 33-year study. Note on empty voting and record dates, 232. Empty voting. O voting rights remain in person who sold economic interest between record date and shareholder meeting. 48. O most statutes account on separate date closer to shareholder meeting and some don't. O economic ownership. O voting rights. O and assigning votes. O Hardys have more votes than shares. O example about put options in Hong Kong. Black small square borrowing shares and share lending market around rate. Black small square hidden amorphable ownership. Black small square allowed shareholder to block a hedge fund's buyout that would benefit all shareholders and sold short record date. O shareholder who owns shares at close of business on record date have the right to vote at the meeting, which is often a month later. Record owners are a different party from beneficial owner. Beneficial owner is the actual owner by street name. Are owners identified as institutional investors, banks, brokers, regional stock depositories place stock under different than street name. B. Financial institutions and their advisors, 235. Shareholders may vote on fundamental changes such as right to elect directors, amend certification of incorporation, sale of substantially all assets, dissolution, economically significant murders, and if proper to amend bylaws. Notes on the role of shareholders under modern corporate practice, 235. Ronald J. Gilson and Jeffrey N. Gordon, The Agency Costs of Agency Capitalism, Activist Investors and the Revaluation of Governance Rights, 246. Brav, Jiang, Partnoy and Thomas, Hedge Fund Activism. 49 Corporate Governance and Firm Performance, 247 Note on the Problem of Freeriding, 251 I-89-3. Vote Buying, 252 Portnoy v. Cryocell International Incorporated, 252 Plaintiff hit by cab owned by several companies owned by Carlton. Plaintiff argued fragmented structure of organization, i.e. owns several cab companies consisting of 3 cabs by principality intentionally reduces ins. Recovery ability for torts, and entities were underfunded in a way to be evasive of liability. Alleging practice was consonant with fraud. Carlton not held liable to plaintiff because business arrangement was lawful and medallions are judgment proof in New York. 4. Funding proxy contests, 259. Rosenfeld v. Fairchild Engine and Airplane Corporation, 259. Heinemann v. Datapoint Corporation, 267-5. The allocation of power between the board and the CEO, 267. Notes on the management of publicly held corporations, 268. Marcel Cahan and Edward Rock, Embattled CEOs, 270. Jill E. Fish, Book Review of Macy, The Overstated Promise of Corporate Governance, 271. Note on the role of takeovers in the structure of the corporation, 272. Shareholder info rights under state/fed law. Inspection of books and recs. 50 DGCL SS 219, 220 Reverend MBCA SS.7.20, 16.01 to 4 New York Bus Corp Law SS 624 case hashtag CiteOV, McKesson Bach Incorporated, SCDE 2002, Bach restatements lower past revenues for 3 years after audit, after takeover limits of right rule. SS 220 SH investigation matters reasonably related to shareholder interest, reasonably related, corporate wrongdoing during SH ownership, Corp docs and TPSP prepared docs unless relevant to SH of parent, not entitled to subsidiary records unless alter ego/fraud purpose, proper. Purpose, notes on SH inspection rights. I. No phishing, the credible basis request by PPE. 51 SH resort to state law for access since PSLRA 95. PSLRA heightened pleading requirement, particularly establishing standard of knowingly, recklessly. Pre-trial motions resolved before SEC fraud discovery process. MBCA applies to specific docs in 16.02 Gen Rule. Can supplement state/fed law. SH acting in good faith and for the purpose of advancing the INTs of the corporation or protecting his own interests as shareholder. GF proper purpose. Some states shift BOP to def. To prove purpose is not proper if SH owned greater than 5% 46 MO in New York. CL survived NBCL S624 but isn't absolute right but can enlarge if relevant and necessary for proper purpose. Proper purpose. Mailing list for proxy solicit FinL condition not for personal benefit. X Honeywell lost v. Pillsbury for mailing before communications pre-anti-war. 52. For mixed purpose. SH lists, common may not be specific enough for these corporate books and records. CH13 SH suits. Intro and background note. A. SH derivative action available because DNO hesitant to bring COA against colleague B. Seminal case sets forth proct standing. Circa 1855, Dodge v. Woolsey I. That corp has valid action it doesn't pursue to. PL, SH, are to sue on behalf of Corp D. Strong bulwark for managerial self-dealing but subject to abuse. Strike suit E. Needs to undergo cost-benefit analysis. I. SH benefit 10 to 90 shares. Less than $1 is insufficient to. Substantive claim 3. 1 PL. FRCP 11 Sanctions applied. G. ALI principles of C. Governance SS 7.04. A. 1. H. Notes I. Who can bring a derivative action to? SH status, standing REQ holding shares for pendency of case 3. Exception 1. Merger purposefully designed to freeze trading for. Exception 2. Business reorganization SH definition is expansive page 886 standing continued. 1. Where undefined 2. Rec ownership, not requirement 3. Unregistered ownership 4. Legal ownership, not required 5. E-ownership, legatee okay. 6. SH of parent co. can bring action on behalf of subsidiary. 7. Creditor, bondholder, holder of convertible bond ordinarily has no right to bring a derivative suite, until converted or if obligated to convert, J. The proxy rules, I, and intro 2. Proxy holder. 53. 3. Proxy, form of proxy, proxy form 4. Proxy solicitation V, proxy STMT 6. Proxy materials K, SEC's SS14, A, and copyright L, SEC's Act Rules 14A-1-14, 1-6, 14C2, 14C3, SCH14A, SCH14CM, form of proxy I, notes an overview of the proxy rules 1. Background A. Origin to treat abuses such as fraud proxy solicitation, 1930s. B. 14A Rules 2. Format questions 3. Short slate proxy, 14A 4D. A. Competing solicitations for BOD elections. BOD solicit SH. ABCDE-XY. Short slate. DEXY. 4. The universal proxy A. If two proxies are submitted, law recurs SH can choose among candidates rather than all or nothing B, anti-bundling, of unrelated resolutions, for avoid/eliminate coercion I, sued to compel EA. For items to be separately presented rather than single issue, whether to amend articles, court enforced anti-bundling Rule 5. Mandatory full disclosure A, merger B, cert amendments C, BOD elections I, Rule 14, A-3, items 7 to 8 must disclosure annual salaries of 5 highest paid executives 1. Plus salary 2. Plus stock 3. Plus bonuses 4. Plus deferred comp 5. And COI. 54. D. A delivery providing SH with the website where the materials are available at no cost. Rule also requires companies to provide via one state class mail PP copies of the materials if required by the SHE. 10K differs FR 14A3. C. Annual report F. Annual report to be free from material misrepresentations. G. Committee details. Meeting frequency. Audit. Comp nominating board committees. H. Filing with SECI. Proxy filed 10 days in advance of BOD election. Auditor selection. Compensation. Ratification J. New York has a 5% test per Studeraker Corp. v. Gitlin, 1966, 6. Newspaper print A. CLX. Of painting rosy picture for SH vote B. Exclusions. Publicizing Dex C. 14A2, B. 2, when proxy comment to less than 10 people 7. Balance free speech protection W/proxy disclosure requirement in Gas National v. Osborne, 6, TH Circle 2015, 8. Issue was comment and exception 9. Chat rooms page 3061. Proxy rules, SH access. A. The dissidents access provision, Rule 14A7. SEC SS 14A7 security holder must provide the RECUTE postage and sufficient copies of the materials to be forwarded. B. SH proposals under Rule 14A8. Rex 1% or $2,000 shares for at least 1 year proxy not required for ordinary bus, 14A8, I. SEC's Exchange Act Rule 14A8 note on no action letters NAL's interpreting Rule 14A8 NAL is opinion from staff if a proxy may be omit wrongful proxy is one where both matters conflict and SH could not logically vote in favor of both. Gibson Dunn SH Proposal Developments page 308. 2. Overview of SH Proposal submitted I, Social 2. Enviro 3. Gov 4. Corp Civic Engagement. 55. V. Exec Comp 2. Overview of SH Proposal 2. SH Proposals NAL Recs Most Common. Ordinary Business. Notes on Settlements of SH Proposals. C. SH Access to the Nominating Process. Nominating Committee Proxy Statement Balkanized BOD's Leg Dev, DE and Model Act Business Roundtable v. SEC, DC 2011, ODFA invalidated 14A0110 holding. Arbitrarily/capriciously adopted OFOIA/OMB materially misleading proxies and Rule 14. C. 9 SEC's Exchange Act Rule 14A9 note on JI case v. Borak. Allows SH to bring private action for proxy rule violation antitrust treble damages note case court v. O issue. Is private remedy implicit in statute if factors are relevant? Black small square CL in support. Black small square leg int. Black small square scheme purpose imply PL relief. Black small square COA 1 usually relegated to state law. O note case Wilson v. Great AM Industries O rule. EA, SH receive notice of MTG accompanied by plan of the merger O note, on the standing of fault in private actions under the rules. Black small square knowledge of the falsity or reckless disregard. Black small square PL must show fault. O note on state law page 330. CH15 note on further proceedings in Mills v. Electric Autolite, merger rescission analysis. 1. Mills holding on materiality of alleged defect, misstatement or omission in proxy statement is one of heightened significance if there is a decisive effect on voting and causal relationship between violation and injury. 2. Significance of an omitted or misrep fact to a reasonable investor might consider important. 3. Low standard equals management liability for Rule 14A9 disclosure policy violation. 56. 4. Other materiality defects from Gerst, Smallwood SEC v. Texas Gulf Sulphur Co., 1968, 5. Note on the standard of fault in private actions under the proxy rules A. Absolute liab. For misleading and or materially false proxy STMTSFR Gerstel Gamble. Sugom B. PL. To show fault C. Falsity scienter require for private COA D. Reckless disregard E. SL2 blunt a tool to correct proxy STMTSF. Note on state law, proxy rules on adequacy of disclosure for SH vote oft similar to material in CH.10. CH6 personal liability in a corporate context. I.e. intro, publicly held companies, private core, and close core A, issue, close corp K around corporate formalities I, unified strategy, close corp build into existing code 2. New York Model Act strategies, special treatment for close corp 3. Statutory close corp with qualifiers by number of SH and exchange B, note on non-electing corp I, stockholders agreement 2. Doctrine of in-depth legal significance C. Voting arrangement at the S level I. Case Ringling Brothers Barnum and Bailey combined D. Notes on SH voting AG and irrevocable proxies I. SH voting AG aka voting or pooling agreements 1. Type 1 page 373 2. Type 2E proxy coupled with an int I. SS 118 exception to agency rules gives rise to irrevocability 1. SH equals P2. Proxy holder equals 2. Agency law implications 1. Term at will 2. Breach of contract liability. Page 374 case hashtag Haft v. Haft. B. Voting trusts. See note card for definition ceremonies payment of DIV 10-year duration judicial scrutiny in 1904. 57. Legitimized by legislation functions to coordinate minimum SH to increase voting power case. Abercrombie v. Davies, When voting trust not legally compliant, the A's agreement not given effect as voting agreement. BC enforced voting trust even though failure to comply with voting trust statute. Oceanic Exploration Co. v. Grinberg. C. Classified stock. DGCL SS 102, A, 6, and 212, A, Model Bus Corp Act, $6.01, 7.21, 8.04 used to control BODs validated explicit or implicit by stat allowing one class of stock. 3. Agreements controlling decision that are W/ in the board's discretion. A management by agreement in close corp. B. Case X McCord v. Stoneham, leave them where they found them. CTs don't evaluate K on PP grounds. C. Note on Clark v. Dodge, 1936, page 383. Valid AG. Described between DIR and DIR MNGR, whereby 75% SH would vote in Clark so long as he observed faithful F competency and set salary as percent of Inc. 2. No damages to anyone, not illegal, no attempt to sterilize BOD. Case hashtag Gawler v. Gawler G. Note on further proctings from Gawler H. DEL Corp. Law SS 102, B. 1, I, MBCA SS 2.02, 2.06, 8.32, and 8.01, B. J. In New York Bus Corp. Law SS 20K, Cal Corp Code SS 158, 186, 300, 312. CH7 Close Corp. 3. Supermajority voting and quorum requirements at the SH and board levels. 3. Unanimous requirements in Core Cert of Inc. or AOI are antithetical to basic concept of Corp Gov by majority rule, from Benettini v. Kenton Hotel cited in Sutton v. Sutton as leg int for def. In laws on to unanimity provisions in Cert. 4. Fiduciary obligations of SH in Close Corp. 4. Donahue v. Rod Electric Type I. Note on Nixon v. Blackwell 1. No are for SH to be treated equally. 2. ESOPs and key man insurance arrangements are common, no facts shown to contrary, i.e. not Close Corp. 5. Involuntary dissolution suits for close corporation at dissension. 5. Page 442. Oppression. 58. Proof of oppressive conduct. 2. Oppressive, harsh, and wrongful conduct. A lack of probity and fair dealing in the affairs of the company to the prejudice of some portion of its members, or a visual departure from the standards of fair dealing and a violation of fair play on which every shareholder who entrusts his dollar to a company is entitled to rely. 3. Violation of strict fiduciary duty. 1. Of utmost GF and loyalty owed by partners inter SA. This standard, which is based on the analogy of Close Corp SH who are active in MNGMT to Gen partners in a partnership, is theoretically higher than the GF and inherent fairness standard normally applicable in a Corp. 2. Conduct which frustrates the reasonable English case law expectations of investor. 3. Reasonable expectations doctrine has expanded to the U.S. 6. The special problems of SH in Close Corp. Page 456a. Arbitration. Arbitration of claims of a derivate nature are not against public policy in a Close Corp. Notes re. Ringling Brothers AAA Stats FR 4 years in the late 80s were 1,000 Close Core disputes I/A/O not $18 million stock valuation alleged breach of K mismanagement wrongful discharge breach of FID. Duty if involving IC and ARB may be imposed by stat without an ARB. CL. In Charter CH8 Limited Liab Company. Page 459 Dell Limited Liab. Co-Act S18-101, 107, 201, 301, 303, 401 to 2504. 59. Casemeyer v. OKA Seatbur Laws Enforcement Common 1. Intro. Formation and MNGMT of LLCs. LLC Def. Non-corp entity formed under stat. That combine corp and PS elements. Owner/member have L. Liab. File art of org. O members often are managers. O operating AG sets forth RS an obligation of managers principal place of business. O where LLC are formed. O Uniform LLC Act is not spread broadly. O members owners managers not liable for debts obligations and other Ls even in contract or tort, even if the appearance of management. Case #racing. At Arts of Org, filed with Secretary of State name address of principal place of business managers / members and managers service of process duration / dissolution plans B, operating agreement / LLC AG. Conducting affairs governance capitalization C, rules for when op AG. And articles of organization are in conflict DE gives max effect 2R2K and LLC AG alternatively. Art paramount if they conflict with provision in the op AG. Articles control in ULLCA SS 112 D. D. Default rule, re-member management. Members manage unless set forth otherwise in Articles of Org. Members can have auth to bind / coextensive of management, 18 to 402, D. Series LLC gives varying levels of authority among managers and SH that requires master LLC's operating AG. Specify distinct layers of overlapping / distinct O powers O liabilities O objectives reprop. Case #EST. Of Collins, page 465. 60. Notes on members' rights. 1. Member vote generally 1 per capita unless otherwise agreed to. Inspection of books and records. Member entitlement for proper purpose or reasonably related to members in 3. Distributions pro rata according to member contributions for. Member INTs include A. Governance RS and financial RS may be assigned transferable pledged by unanimous consent / majority consent if allowed by stat. B. Statutes may allow assignor to lose member RSC. Pledger loses distro / fin LRS while in pledged. Case #OHV in Monroe. 2. LLCs and the distinct entity concept. A. The entity feature and its disregard. Case 3519 to 3513 Realty, LLC v. Law page 473. Case #Green Hunter Energy. B. Suits on behalf of the LLC. 1. Ex Sotis v. Wolf. Leg hist for expanding legal action beyond derivative, on behalf of, to direct, i.e. member can sue for LLC directly. Problems with forum for diversity of citizenship based on principal place of business. Case #Elf Atikim tried to overcome Arbit AG. And she directly and derivatively against fellow member Jaffer for misappropriating funds and business opportunities of said those rights were contracted away by AA. 3. Fiduciary duties, borrowed from corp law, stat generally call for member liability by A. Gross negligence B. Bad faith C. Recklessness D. Equivalent conduct E. Op AG. Allowed to limit / define scope of fiduciary duties i.e. GF and FD. F. Case Salem v. Feldstein page 483 G. Case VGS v. Castill. 61. H. Solar Cells Incorporated v. True North Partners, LLCI, SS 18-1101, E. Dell LLC Act, may not limit or eliminate any act or omission that constitutes a bad faith violation of the implied contract covenant of good faith or fair dealing. J. Entire fairness standard equals fair notice, fair dealing, fair price K. But self-dealing is not manifestly unfair L. Duty of loyalty is not manifestly unfair M. Duty of care not auth intentional misconduct N. Implied covenant of GF and fair dealing cannot be contracted away by Op AG. Allowed under Dell LLC Act 18-1101, E, O, GF Def Sci, RSTMT 2 ND of KS2. UCC 2-101, 23. UCC 2-103-4. Contracts SS 437V, CL Dunlap v. SF6. CL Dan Relv Pavan Camp on Corp v. A Building and Const Trades Council of Philadelphia and Vicinity PA S. CT 1963p, exercise discretion under K in GFQ, implied rights and obligations must be indispensable to intentions of parties are so fundamental to the K that parties need not negotiate of these expectations BC. Remedy on the basis is rare and used only as occasional necessity to find rights and obligations S. Duty to perform express K terms in GF not NIS SGF overall T. Unforeseen contingencies may be incorporated into K due to limits of human knowledge and costs of NIGA U. Implied covenant is not a means to relance economic INTs or to protect a party who should have protected themselves for disassociation and dissolution A. Diff approaches IDE indirectly 18 to 306 allows for voluntary and involuntary disassociation 2. Narrow circumstances 3. May warrant dissolution, i.e. 1. Illegal 2. Ultra vires 3. Fraud 4. Oppressive, harmful contact 4. ULCA SS 701, 4. Copyright, 2, 1. Oppression-dissolution, as in partnerships, 2. Various other approaches I. No right to withdraw 2. No right to buy out 3. Different for remulations 1. Are to contributions. 62. 2. Are to FMV of value / distro member is entitled to 3. Exclusion of goodwill for wrongful with D4. REQ dissolution. Don't require dissolution for cost avoidance 5. Some only require dissolution if purpose frustrated. CH9 The duty to act with care, in good faith, and lawfully. 1. The duty of care, basic standard of care. Model Bus Corp Act S 8.30, 8.31 Cal Corp Code SS 309 New York Bus Corp Law SS 717 Ollie. Principles of Corp Governance S 4.01, A, B, 4.02, 4.03 Note Issue. Causation O Duty of care by omission O Attribution to one director O Dependency / interrelatedness of DIR. Acts O Spousal Director Inactive Virtual Figurehead Director O Note Case # Barnes v. Andrews Opinion by Learned Hand. 1924 Andrews induced to serve as DIR. By Maynard of Liberty until receivership. Black Small Square Duty to inform himself recognize prod delay personnel conflicts. Black Small Square toward of omission and estimates on positive action. Black Small Square and % of success in that act on co/fellows. Black Small Square and loss attributable to failure to achieve success. Black Small Square director may threaten to withdraw if attempts are futile. Black Small Square holding. Barnes that bus judgment rule is a presumption, BPO to prove injury and breach of duty by prima facie showing of L. Then, BOP shifts to def to show transaction was entirely fair O note case, Seed & Co. v. Technicolor Incorporated, share price negotiation without best interests explicitly rejected. Ill-informed decision. B. The bus judgment rule. Case # Kamen. 63. ALI. Principles of Corporate Governance SS 4.01, C. Standard of Conduct SOR - did agent deal fairly SOR Standard of Conduct plus SOR are divergent often in corporate law. BJR. D plus O duty to corp is good faith, vest INTs of corp, shared by ordinary prudent person in like circumstances duty to monitor duty to inquire duty of prudence in decision-making duty to employ process. Analysis. BJR deference, if 1 to 4 are not met equals reasonably SOR, but if 1 to 4 are met equals rational SOR. 1. Make decision, inaction not subject to BJR unless deliberate. 2. Informed himself. 3. GF. 4. Financial int in subject of decision. Note case X. Selheimer v. Manganese Corp of America. 224 A2D 634, PA 1866. Decision may be unreasonable, not irrational, if there are good reasons for or against the decision. but under the circumstances a person of sound judgment, giving appropriate weight to the reasons for/against, would not have made the decision action for waste. Black small square bad faith in re Walt Disney co-derivative litigation, 2005. Black small square transaction so one-sided that no rational business person would believe it represented a fair exchange, so inadequate in value that no person of ordinary sound business judgment would conduct. Notes after Caremark and Massey include AM International Group Black small square self-disclosed accounting errors Abbott Laboratories Black small square FDA warning to deaf directors new. 64. Citigroup IC weak and failed to act before subprime MTG market crash ABA Sect of Business Law, Committee on C Corp Laws, Corp Directors Guidebook page 581 6th ed. 2011, include written policies, reviewed regularly, training to employees Black small square bus con cut. Black small square co. Black small square environmental health and safety. Black small square ABC. Black small square antitrust. Black small square insider trading compel program. W/adequate resources and authority to perform. Compel oversight charged to audit committee, governance, or risk committee compliance and legal affairs committee Black small square whistleblower hotline policies. Black small square compliance clear access for reporting to GC. Black small square comp Eisenberg, the BOD, and internal control page 582 from COSO for volume report on IC def of IC, process affected by entities BOD, management, and other personnel, designed to provide reasonable assurance regarding the achievement of objectives in 3 categories Black small square effective and efficient ops. Black small square reliable FinL reporting. Black small square compel W/applicable laws and regs. Interrelated components. Control environment RA control activities information and communication monitoring note on civil L of DNO to third persons, rather than the corp, covered previously, page 582 derived FRCL. 65. Black small square rule, RSTMT2ND of agency, provides insulation for agents acts in course of day to day not PL. However, a tort is not cloaked and DNO can be individually liable along W/corp liability shields page 583. Black small square direct limits 2L. Insurance indemnification. Black small square VA core code $13.1-690. Black small square DGCL SS 102 B7. Black small square model bus. Corp Act SS 2.02 B4. Black small square case #Malpede. Black small square note case #Leal v Meeks. TC would find PL for self-dealing if sufficiently pled. SC reversed as to non-interested, impartial, board members unless they were grossly negligent DNO liab. Insurance form of DNO liab insurance. DNO policy. Black small square to reduce discretionary/mandatory indemnification of BOD duty of care liability for conduct while acting in capacity type 1. Corp reimbursement. Protects corp for duty of care type 2. Personal coverage. Protects director for duty of care note on crim L of DNOS. 603 can give rise to civil L through Miller note case film recovery cyanide used at a plant to reduce used tapes to silver. Press charged with murder for failure to move complainant employee. Foreman who died from exposure, 5. The responsible corp officer page 604. Power to control even if not exercised A. Acme note case I, US v. Park. Acme's rodent unsanitary warehouse in Philadelphia and Baltimore led to conviction of corp officer even when oversight was outside his purview 2. Holding corp officer responsible for entire organization 3. US v. Dotterwich, 1943, shipment of prescriptions into IC4. M. Because public interest in reduced public danger v. Positive duty to seek out and remedy violations. 6. Positive duty to take measures to ensure they won't reoccur. B. Meyer v. Holly. Interracial co-allege FHA violation owner and agent, but 9. TH circle reversed because vicarious liability is limited to Corp employee acting for/on behalf of Corp, not owner/officer 6. Microsoft v. Ion, Min 2007, not further extended unless 7. State v. Arkell, Min 2002, in light of leg. Int. 66. CH10 Duty of Loyalty, page 609. Gantler v. Stevens, page 609. Kane, Fish, Griffith, and Davidoff Solomon. How corporate governance is made. The case of the Golden Leash must be disclosed per SEC O Watchtel bylaw. Prohibits Golden Leash in bylaws self-dealing transactions O common law. Black Small Square Marsh, are directors trustee? Conflicts of int and corp morality. O Gen Rule 1860 foot S80s. Contract between DNO are voidable at instance of SH regardless of black small square fairness analysis or black small square number of disinterested directors that approved contract because immediately suspect. Plea 2 MDSC opinion. The second prong was eliminated by 1910. Only explanation is analogy of trustee dealing with Sestuy K trust. Statutory approach O defensive end/defensive end O MBCA O ALI O notes on the effect of approval of self-interested transaction by disinterested directors. Black small square ratification generally. Complete defense shift test from fairness to waste. On judicial review, shift BOP to PL leaving, SH protective test in place. No effect O New York Stock Exchange listed company manual SS 312.03. Black small square notes on SH ratification. Corwin v. KK gives modern PP regarding efforts to obtain best price. Analogized to agency law, 882, 91, 100, 103. DGCL SS 204-5 allow ratification to revive defective Corp Act's procedural rules formed by case law. OSH may not ratify to waste except by a unanimous vote. OSH ratification per Gantler had to be separate FR vote on trans Corwin. This position allows bundling too. Compensation A, ST salary, bonuses, tied to ROE, ROA, ROI EVA, cost accounting, B, LT, I, in new grants of restricted stock, see note card 2. Stock options, see note card 67. C, long-term incentive plan P/O, i.e. ROA greater than 15% for 3 years. D, note on tax treatment of exec comp i.e. X, incentive stock options, not taxable when issued or exercised, only taxable when sold for capital gains. 2. Non-qualified stock options, not taxed at issue but when exercised. E, multifaceted tax leg, 2017, I, eliminates public co-exception for performance-based compensation which previously allowed deduction of CFO, CEO, and 3 highest paid officers received 1 mil/individual F, DGCL SS 141, H, 157G. MBCA SS 6.24, 8.11H, ALI Principles of Corp Governance SS 5.03 I, NYSE Listed Co-Manual SS 312.03, A, J, SEC Reg SK, Item 402K. In Re Walt Disney Co. Deriva Litigation CH9, Sect. 2-3. Note on spring-loaded options. A, issuing stock options before a big announcement. B, indirect deception if BOD do not have explicit SH auth. C, not considered insider trading, but of issuance with knowledge of artificial low hashtag, i.e. not loyal GF Act. D, can be expressly authorized by SH. I, bullet dodging. 2, backdating stock options. 4. Note on CEO compensation. A, Great Disparity 140:1 to average 500:1B. Price theory. High CEO comp is priced to induce better performance in junior positions. C, retirement benefits opaque to conceal costs. X, thinly disguised stock options create CEO as creditor. Condition 5. Harwell Wells, U.S. Executive Compensation. In Research Handbook on Executive Pay Policy in 1960 to 70s. B, Treaty of Detroit. C, New Deal Order. D, For Treaty Concordat, Union Erosion, E. Def S in Social Policy 6. Notes on Address Executive Compensation through Disclosure and Governance 7. Use of Corp Assets. The Corp Op Doctrine A of Face PL and SUBJ to Disgorgement/Restitution 8. Meinhard v. Salmon Unbending and Inveterate Tradition 9. Ollie Principles of Corp Governance SS 5.04-510. RSTMT 2ND of Agency SS 388A, plus non-complete 11. DGCL SS 122, 17, 12. MBCA SS 2.02, B, 8.7013. ALI Principles of Corp Governance SS 5.05, 5.06. 68. 14. Notes on the Corp Opportunity Doctrine 15. Duties of Controlling SH 16. ALI Principles of Corp Gov SS 5.10-1217. Regulating the Exercise of Control 18. Note on Family Controlled Public Cost 19. Class Wars A. Note case hashtag in Retrados Inc. Shareholder Litigation B. Facts. VC wants to divest of Co. to encourage a sale. It undertakes a MIP with preferred SH arrangement. Evokes sale with no dollar for common SH by Management Incentive Plan, MIP. Min sues for breach of duty failing to generate value for the common SH when 13% was reserved for preferred SH. On attack, the court decided that the common won't fetch a value before or after merger because of nature of investment and lack of attractiveness in VC market. Their holding the common STK had no econ value before the merger. The CS received in the merger the substantial equivalent in value of what they had before. The common lose notwithstanding the fairness analysis and showing of self-interest. 20. Case hashtag _ Zon V. Transamerica Corp Tobacco sold to Philip Morris by Inns Co., a majority SH. Calling/redeeming all stock, Class A, because the COI/charter allowed for conversion of Class A-B. Per court's statutory construction, the conversion should be allowed. Case hashtag _ Nemec V. Schrader page 719 FRCH 9. 21. Note on the duty of discal by controlling SH under DE Law 22. Citing Lynch v. Vickers Energy, 1977, A. Duty of candor I. Complete candor B. Completeness over adequacy C. Material/germane facts D. That are relevant to SHE, regardless whether fact determinative material misstatements X. Shell 23. Sale of control case hashtag Zetlin v. Hansen Holdings, Inc. Min SH want purchaser of May SH POS at Prem to offer Prem to them to scale. No rule at CL requires this. The suggestion about taking up with leg, not judicial system. Affirm with costs. 2 scholarly articles about the ridiculous leg proposition. One for the other against. Case hashtag Proman v. Feldman. D. The sale of a corp office SEC Rule 14, F. $1 LIPCG $5.16. Case hashtag Essex Universal Crop v. Yates note on tag along and drag along provisions tag along. Offer XWMTN/SH on small terms drag along. Min must AG2 sell shares on SM terms. 69. Book notes CH11 the anti-fraud provision Sect 10b and Rule 10b5. 1. An intro to Sect 10b plus Rule 10b5. Sector 10b, Sector 10b5. Case hashtag _ The Wharf Holdings, Limited v. United International Holding Incorporated, 2001, SCOTUS. SCOTUS unanimously views an oral option agreement as a security and finds it to be a manipulative contrivance, because the party extending the option for value knew it was valueless because they had no intention to honor it. 10b Securities Law Liability. The Supreme Court sets forth the elements creating liability under the Securities Exchange Act of 1934. 10b most comprehensively in the Wharf Holdings, Limited v. United International Holdings Incorporated. 2001. Misrepresentation. 10b of the Securities Exchange Act makes it unlawful for any person to use or imply connection with the purchase or sale of any security, any manipulative or deceptive device or contrivance in contravention of such rules and regulations as the SEC may prescribe. 10b-5 promulgated by the SEC fills in more explanation as follows. I. Any device, scheme, or artifice to defraud. 2. Any untrue statement of a material fact. 3. Omission of a material fact necessary in order to make the statements not misleading, or 4. Any other act, practice, or course of business that operates as a fraud or deceit. 17 CFR. SS 240.10b5, 2000. Nexus. United States Code Title 15 SS 78J assumes that misrepresentation stated above from 10b of the Securities Exchange Act of 1934 occurs in connection with the purchase or sale of any security. Security as defined in WARF includes both any option on any security and any right to purchase stock. 15 U.S.C. 78C A 10. 70. Interstate commerce. 15 U.S.C. SS 78J requires use of any means or instrumentality of interstate commerce or of the mails, or of any facility of any national securities exchange. Materiality. WARF credits Basic Incorporated v. Levinson, 1988, for including the element that misrepresentation must be material. Definition of materiality set forth in Basic is quoted from TSC. Omitted fact is material if there is a substantial likelihood that a reasonable stockholder would consider it important in deciding how to vote, or likelihood that disclosure of omitted fact would have been viewed by a reasonable. Lamarche P.G. Investor as having significantly altered total mix of information made available. Scienter. WARF cites Ernst and Ernst v. Hochfelder, 1976, for the required scienter element and defines scienter as intent to deceive, manipulate, or defraud. The scienter requirement may be met by recklessness in a private action for fraud. 10b and 10b-5 cause of action, which is defined as highly unreasonable conduct, involving not merely simple or even inexcusable negligence, but an extreme departure from the standards of ordinary care, and which presents a danger of misleading buyers or sellers that is either known to the defendant or is so obvious that the actor must have been aware of it. Primary participants. Central Bank of Colorado affected the parties that can give rise to a 10b and 10b-5 violation when its aiders and abettors analysis was not determinative. Thereafter, the courts arrived at a definition that any person or entity, including an accountant, lawyer, analyst, or bank, must have engaged in manipulative or deceptive acts or have control of direct or indirect nature to be liable under the securities laws. Short of an independent act, the preparer can only suggest a statement for another to deliver and should therefore not be liable in a private action by coupling his acts with that of the deliverer. Standing. In its strict common law form, the only plaintiff parties with standing are the purchaser or seller of a security. The purchaser-seller role does not apply to the defendant party. Causal relationship. 71. Transactional causation stands for the investor's reliance on the misrepresentation. Loss causation is a required finding of proximate cause that damages suffered by plaintiff must in part be a foreseeable consequence of any misrepresentation or material omission. Such misrepresentation touches upon the reasons for the investment's decline in value and is not offset by intervening causes or lapse in time. Damages. A required element is that the plaintiff sustain damages through reliance on the misrepresentation. Note on private actions under Rule 10b-5. Private action not explicit in 10b, but CT finds implied private are of actions in Hermans and McLean v. Huddleston in 1983 in 10b plus 10b-5. What constitutes a misrep? A duty to speak. 1. Periodic disclosure 10K, 10Q2. Transaxional discl AA, transaction for which SH approval REQt B, SH approval REQt C, continuous discls 1-8K2. Events/occurrences black small square auditor resignation black small square discontinuance a mat transaction outside ordinary course of ops black small square direct departure 3. 1 half truth. See note card for emission deft 4. Still gives higher up 2 liab 5. Duty to correct. Black small square be conservative black small square when forecast/accurate at time made is later identified as erroneous 4. Duty to correct. Be conservative. 72. It may arise if the org opinions or projections have become misleading by intervening events 5. Inside trading A10, B5. Not SLB, greater than 10 at X of non-public mat info IA by 2. Cell 3. Draft 4. Non-programmed V. Not less than 10% C. Entanglement when company. So involved with analysts' reps or earnings projections that it assumes a duty to correct materials errors in those STMTSD, opinion STMTSI, I believe too. Quantify source 3. State of mind must be stated accurately E, forward-looking STMTS there are 4 SHs, 21E, C1, I. B speaks caution doctrine 2. SH1. Using meaningful cautionary STMTS. 2. PL must prove by actual knowledge, exceeding recklessness, that STMT was false or misleading 3. Oral STMT 4. Bespeaks doctrine same as 1 but specifically tailored to STMT, not boilerplate cautionary STMT 5. Except A1PGB tender offer 6. Materiality A, case #TSC Induster V, Northway Incorporated, CH5. Materiality definitions. I. Omitted fact is material if there is substantial likelihood that a reasonable stockholder would consider it important in deciding how to vote. 2. Substantial likelihood that disclosure of omitted fact would have been viewed by a reasonable investor as having significantly altered the total mix of info made available. B. Case #Basic Inc. V. Levinson. SCOTUS 1908. SH class certification sought for harm by 3 statements that denied merger when preliminary talks were going on. The merger occurred 1 day after being announced. Co-suspended stock trading with SEC at depressed price affected by DEFS misleading STMTS. 73. 3. Note, move on the probability, magnitude approach to materiality 1. Note case matrix, causal connection is enough. Drug being investigated for complaints it causes anosmia is sufficient whole statistically signed because if SS data regulatory action then it would reasonable investors to warrant discl as material as relative to total mix of info used by reasonable investors. CH11 anti-fraud provision, sect 10B-B-5. 4. Scienter required for private cause of action on 10B claim. 1. The call for scienter, intent to deceive, manipulate, or defraud aiding and abetting eliminated from 10B in Central Bank FR 1994 and Janus. Scienter required for injunction under 10B5. 2. Recklessness intentional conduct for imposing liability. Meets scienter sufficiency for private right of action for fraud 10B and 10B5 COA def FRCL. See note card negligence recklessness scienter /intent. 3. Injunctive relief. 5. Primary participants after central bank, note case, aiders and abettors analysis not determinative on direct/indirect, but on act of any person or entity, accountant, lawyer, analyst, bank, and whether it is of itself manipulative/deceptive and relied upon by party. Hedge fund parent SH harmed by clandestine conduct by one of fund's parents, Janus. Court limits applicability of ANA liability to party with control over statement making a direct/indirect distinction. because preparer can only suggest the statement for another to deliver and should not be liable in private action case. #WV Pipe Trades Health and Welfare Fund standing to sue. Ninth Circle departed from purchaser-seller requirement in note case Blue Chip Stamps v. Manner when IPO prospect is produced pessimistic statements to get rejection and fetch higher price on public market but SCOTUS reversed. Standing is to avoid vexatious litigation SEC proceedings, not a purchaser-seller injunctive relief. Cowan v. Bressler. 74. DCCIR 1984 requires purchaser-seller standing. AAV Resources International v. TriStar Petroleum allows injunction outside PS standing if the PL would suffer a future monetary loss. Defendants need not conform to PS role. 7. The PSLR Act and SEC's litigation uniform standards. 1. Lead PL. Not institutional investor. A. Monitor prosecution. B. Maintain agency cost. C. Avoid lawyer-driven suits. 2. Some other reforms on professional/establishment PL and attorney and Rule 11 sanctions. 3. SLUSA closes state bypass, SEC's Litigation Uniform Standards Act with DE carve-out. 4. SLUSA and the purchaser-seller requirement. Merrill Lynch Pierce Feller. A. OK investors lose dollar based on false analyst reports was removed to federal court, but removal was improper because SLUSA in connection with SLUSA and 10b5 preempted. 5. Notes on pleading scienter after the PSLRA. FRCP 9b. Fraud to be pleaded with particularity, strong inference of intent. 2. Detailed direct and conduct/recklessness. 2. Circumstantial motive/op, motive challenged. B. Note case Telabs v. Maker, 2007-8. Causal relationship, not in PSLRA 9. 10b5a fraud missed B, caused transaction C. Not trans, but for missed D, reliance E, loss causation, misrep caused econ loss to PL. 10. Litigating transaction causation A, Matt Lighty Def 11. Notes on the forensics of fraud on the MKT. 75.
Fraud on the market.
See note card 9 factors for analysis B. And case sits Kummer v. Bloom C. In re Petrobras SEC litigation D. Wagoner v. Barclays PLC E. Gamco v. Vivendi F. Notes on class cert in fraud on the market cases 12. Loss causation 13. Metzler held insufficient causal connection. Share loss alleged between and misrep when fraud not announced 14. Mine workers, opposite even though fraud was not announced 15. Note on bundling and its consequences. Unbundle bad/good news to reduce litigation 16. The junction of breaches of FID duty and Rule 10b5-1, the common law background. A. Notes on the duties of directors and officers under the CL when trading in their corp stock. B. CL rules seminal case Goodwin v. Agassi, 1933, removes aids and abet rect. C. DNO may not trade in stock without disclosing on all non-public info concerning the corp that he acquired through his POS. 2. Exception special facts Strong v. Repide, 1909. Amassed that government was purchaser of shares in corp dealing in Philippine sugar. So Strong undersold because shares 10 excess as much as government int by way of a broker conducting sale at request of Jones. A POA of Reptide didn't make government negats known to POA Jones, or therefore PL. B. Atrophy, CL atrophy to 10b5 after enactment in 1943, the federal disclose or abstain requirement. Case hashtag in the matter of Katie, Roberts, and Co., 1961. Broker tipping SHs to sell based on confidential info caused SEC to expand scope to anyone with insider info. 1. Special relationship with the Co. 2. Privity to its internal affairs. 3. Correlative duties in trading its SECs. Case hashtag SECV, TX Gulf Sulfur Coke, SEC action needs no standing inside trading by tipper case Chiarella note on the use test under Rule 10b-5. Possessed at trade. Used info in decision. SEC $14 E3 affirmative defense knowing possession effect if 10b-5 plans with safe harbor O licensing O waiver. Rule 14 D3 76. Case #USV. O'Hagan, note on who's a misappropriator, fiduciary relationship def and X's O trust O confidence O act in another INT's O confidentiality O custody, Chestman holding family member who trades in breach of reasonable expectation of confidentiality doesn't necessarily violate 10b-5 facts and circumstances O person agrees to maintain confidence O history. Pattern. Praction. Supports reasonable expectation SEC Rule 10b-5-20 case #Dirk O Scienter FRUS v Newman. Holding O Tipler must know BRD Black Small Square Insider entrusted with F.D duty. Black Small Square Insider breached FD. Black Small Square by disclose confidential info to a tip P. Black Small Square in exchange for a personal benefit. Black Small Square tip P know and still used info to trade or tip others O SEC, selective iscal and insider trading O exec sum, FD is fair discal a recute when non-public info is intentionally, similar FD, / unintentionally, 8K, promptly OSD, Reg FD Black Small Square BGD, rationale. Black Small Square ADV, notice Reg 4 CEOs to post non-public info on FB. Black Small Square note on insider trading enforcement. Black Small Square treble damages. Black Small Square Insider Trading Sanctions Act 1984. Black Small Square BRD-PPE. Black Small Square Avenues i.e. mail / wire fraud stat. Black Small Square reimburse SH of SM, class not to exceed gain. Black Small Square 20A remedy specific to disc or abstain. 77. Black Small Square, for short swing trading under 16b of the SEC's Act Black Small Square SEC SS 16 Black Small Square SEC Rules 3A Black Small Square notes on computation of profits under 16b. Black Small Square note on interpretation of 16b Black Small Square note on unorthodox trans UNDRE 16.6 Black Small Square note on attrition of ownership under Sect 16a plus b Black Small Square no American Catholic Edu Prog Eden. V. Gowalla Black Small Square answers whether creditors to have standing to sue when corp in vicinity zone of insolvency in negative because CR covenants. State / and Fed law are SUF RS Black Small Square case #quadrant struct prods company. LTDV Averton offers limited creditor rights 1. 2. No FDO 2 CR3. 4. 5. 6. Weinstein, 2013, v. A Food Metrics doesn't give creditor standing, regardless, insolvency, no FD owed 4. D+O have no standing to bring derivative acts note on the AS and indispensable PTY2. The nature of the derivative acts in A, case #Thule case #International Brotherhood of Electrical Workers ALI Principle of Corp Governance SS 7.01 case #Barth. 78. ALI position on direct Saint suits in close corp. 4. Individual recovery in derivative actions A, case #Glenn. Recovery goes to corp not SH because creditors RS should not be impaired 5. The contemporaneous ownership rule A, FRCP S327B, MBCA S7.41C, Cal Corp Code SS 800, B1, D, ALI. Principles of Corp Gov $7.02, AE. Case Bangor. Real parties would gain FR lawsuit would be new SH would receive a windfall. Case Rifton applies. Notes on the contemporaneous ownership rules common law still applies by case law, stat. CT a rule. Exceptions. A. Devolution by op of law, if SH inherited FR owner at time of wrong. B. Continuing wrong applied diffly amoung states. Me. Forbes v. Wells Casino, 73 foot, Cont. ing wrong 7th, Winehouse v. Gale, 56, inapplicable 5th, Palmer v. Morris, 63, applicable New York, Chaff v. Cass, inapplicable 5. Demand rect MBCA SS 7.42-44 Ollie SS 703.4.8-13 Cal Corp Code SS 800 B 2 FCRP 23.1 Intro unless excused SH must make demand of BOD before COA Oliveira v. Sugarman of 2017 translates Boland, 2011. To apply heightened INQ when BOD does not have a disinterested majority, otherwise BJR is applied and susceptive to well-pleaded complaint note case. In re PSG any SH derivative action, BJR may be supplanted by modified BJR in NJ. Black small square indup and dissent members of BOD. Black small square acted in GF and do care in investigating SH allegations. Black small square BOD decision was reasonable. 6. Demand on the SH. 79. In mass application of 3, 1 majority of SH may determine if litigation is in best int. Drawbacks are black small square LG number of SH. Black small square delay. Black small square alleged misconduct may not be a matter that can be ratified. 7. Indemnification and ins. Indemnification black small square 1939 no New York stat common law indem by a co of attorney fees indicate DNO only avail if suit benefited co black small square deeders false admission. Plead, negat. Black small square encourage busmen to hold BODPOS. Black small square discourage SH deriv in strike vaults DGCL SS 145 MBCA SS 8.05-8.59 New York Bus Corp Law SS 721-26 Cal Corp Code SS 317 ALI Prink of Corp Gov S 7.20. Case, Waltouch v. Conti Commodity SVS Incorporated. Case examine GF as factor for indemnification, but not exclusive determinant per DESS 145A and F notes thereafter remove indemnification even when the corp is benefited if black small square regulatory infractions / disregard if regulatory scheme case on point diamond. Beyond black small square knowingly misrep case on point Globus against PPO case on point Donaldson O first Golden Baron O even if 16b doesn't require fraud intent reg SK. SEC 512H requires language in prospectus note on the scope of indemnification provisions. Indemnification often extended to agents if black small square not outside attorney. 80. Black small square requires cloak of management off. Black small square not individual conduct must be in the scope of duty. Note on advances. Black small square distinct FR indemnification RB insurance. See Chapter 9, 7. The role of Corp Counsel. Case # Bell Atlantic Corp via Berger, dual rep of nominal and real def S. Notes on problems concerning the law governing lawyers in derivative actions ACP/WP definitions. Page 967, ABA Model Rules of Professional Conduct S 1.6 and 7, and 13 ALI Prink of Corp Gov, Intro 2.7, Reporters Note 8. Deal Litigation and Settlements Note on DE's Antidote for the Epidemic of Deal Litigation Common Issues with Mergers OAM. Of terms O disc only settlement 14A9 discal claims O increase in merger consideration case note in Re Trulia Incorporated failure to procure highest exchange ratio for SH breach of FD9. PLS Counsel fees ALI Prin of Corp Gov 7.17. Case Tandy Crafts Incorporated. Background note on the award of counsel fees to successful deriv acts and PLS. CH17 Corp Combinations, Tender Offers, and Defending Control page 983. 1. Corp Combinations A. Sale of substantially all assets A. DGCL SS 271. SH Assent to transactions divesting of substantially all assets. B. MBCA SS 12.01-2 and 13.02. 3. Case hashtag Hollinger Incorporated v. Hollinger International Inc. Two-part disjunctive test of what is substantially all as which triggers SS 2.71 SH Assent. B. The appraisal remedy page 991 SH make written demand for appraisal either before vote or W/in 120 after A. Statutory development in all states to respond to pre-1950 practice of SH approval on all AOI amendments being and impingement on business. 81. B. DGCL S262C. An appraisal petition greater than 1% SH of 1M may receive stat prejudgment in to resolve D. MBCA S13.01-3 and 13.20 to 26.30. 0.31e. ALI Prink of Corp Gov S 7.21, 7.23f. Cal Corp Code SS 1300, 1311G. States vary greatly in what requirements accepted from appraisal requirement H. Notes on the appraisal remedy I. MBCA-sale of assets, mergers and consolidations to obtain fair value for shares 2. IMD before the effect if the corp action triggering appraisal rule as determined by using customary valuation concepts and without discounting for lack of marketability of minority. See page 992 for definition. 3. Purposeful process 1. Vindicate dissenters Rs 2. Appraisal arbitrage 3. Prejudgment and payment to SH to get ahead of suit 4. Pre-sale post-sale speculation equals PII 5. From Share Honeypot Case 6. 4. Notes on determining appraised value 1. No GF dealing at arm's length deference 2. Fair value equals a value plus MKT value, less than 10% WT, plus earning value, less than 40 to 50% WT, plus DIV value plus deal value. 3. Deal price definition comes from Del v. Magnetar and is said to deserve heavy/dispositive weight bearing substantial probative value v. Notes on exclusivity of the appraisal remedy 1. Is appraisal REQ excessive remedy, i.e. remove injunction/rescission? 2. Analysis A. Is it a legal transaction in corp law B? If so, was it improper? C. Was there fraud/misrep or proxy rule violation? 3. Stat treatment A. Impact of appraisal remedy. Appraisal remedy precludes FDCOA other than fraud/misrep, but precludes unfair self-dealing if arm's length, but not self-interested transactions B. Cal Corp Code S1312C, MBCA S13.02D, ALI Print of Corp Gov S7.24-5C, Statutory Merger A, Classical Mergers I. Legislative Origin 1. DGCL S251 A-E 259-261-2. MBCAS 11.017. 82. B. Definition. Fusion of two constituent corp pursuant to a formal AG. Executed with ref to specific stat merger provisions under which one corp, the survivor, succeeds to the as in ls of the other corp by operation of law I, requires SH approval of both co and convey appraisal right to. File art. Of merger with Secretary of State 3. Issue substock 4. Assumption of rights and privileges by law C. Consolidation definition. Same definition, but one corp fuses into another and new corp is formed D. Short form and small scale mergers I. Historically, all stat mergers required SH approval by 2/3 vote of outstanding shares of each constituent E. Small scale mergers F. DGCL S251 F. G. MBCA SS 11.04 G. H. Secondary art explains leg. Int to give SH voting RS were reasonable, but not where the same act by another title would not give rise to SH oat/appraisal R at a minute SH must have 20% and I. DGCL SS 253J, MBCE SS 11.05. K. Transaction, aka parent-subsidiary merger, may be carried out by parents BOD without parent SH vote and sometimes without sub-SH vote I, floor often 90% to 100% too. So parent can eliminate minority SH without D. The stock modes and the de facto merger theory A. Stock for assets, see note card B. Stock for stock, see note card C. De facto merger requires SH vote and appraisal right available to SH of both acquiree and acquirer. Case hashtag Heriton v. Arco Electronics, stock for assets in sale of A's statute combined with merger statute is not illegal. Case hashtag Ferris v. Glen Alden Corp, upside down format for greater benefit to keep smaller, PA, organizations carryover tax benefit and apply DE laws to avoid SH vote. However, PA's 908 overlay from case law applies to protect SH, prevailed notwithstanding legislative intent of amendment purpose to end the 908 overlay. D. Notes on Ferris I. View diff category of a merger as a statutory merger if the classification is illusory. New leg supplants old decision 2. NYSE listed co-manual SS 312.003. CalCorp code $152, 160, 168, 181, 187, 194.5, 1001, 1101, 1200 to 1, 1304. MBCA S 6.21 F 83. E. Notes. Transitional Corp Law Orientation I. Gen Rule on Assumption of L. A mere sale of corp prop by one co to another does not make the purchase liable for the liabilities of the seller not assumed by it. 2. Exceptions. 1. Express/implied assumption by seller. 2. Consolidation transactions. 3. Purchasing corp is merely a continuation of selling corp. 4. Fraud transaction to escape liability. 5. Successor liability through the prod. Liens, tort liability avoid A. No available remedy B. Knowledge of acquiree C. Party in a position of prevention, public policy E. Triangular mergers and share exchanges A. In notes. See note cards for definition B. Stock for assets I. PP intensive to take liabilities on selective basis by way of 1. Assignments 2. Deeds 2. Forward triangular merger 3. Reverse triangular merger 4. Stock exchanges V. Equity conversions F. Freezeouts A. And notes on techniques I. Dissolution 2. Sale of assets 3. Debt or redeemable prep stock mergers. 4. Dollar out mergers. V. Reverse stock split B. Note on purpose test. Outmoded except MA and New York note cases I. MA. Coggins 2. New York, Albert C. D. Streamlined back-end merger procedure I. Go to 3. Page 4. 1045 V. And type up the factors C, assessing the target's response. Case hashtag Unocal Corp v. Mesa Petro, selective self-tender offer OK in 1985 per D law, but supersede by all holders rule. 2. Note on Unitron Incorporated v. American Gen Corp, page 1068. 84. I sums up Unocal as proportionality test, or range of reasonableness, and adds draconian standard 2. Proportionality, nature of the threat associated with a partial hostile takeover offer sets the parameters for the range of permissible defensive action 3. Draconian, defensive measures that are either preclusive or coercive meets draconian definition 1. Preclusive operation precludes acquisition 2. Operation to force management's preferred alternatives on SH4. Notes on Unocal, all holders rule supersedes case result V. All holders rule included in OLLI S 6.02, A-copyright 6. Some jurisdictions/decisions hold to logic and heightened deferential scrutiny 7. Poison pill 8. X. From Toll Brothers 9. Flip over pill page 1073 for definition X. No SH voting requirement 11. Dead hand provision, not comport to DE Law S141. R's plan cannot be redeemed except by the incumbent directors who adopted the plan or were their designated successors. 12. Delayed redemption. Same as dead hand provision except restrictions on new directors are effective for a limited 6 months period. Delayed redemption is also invalid 13. Note on dead hand proxy puts 1. Quases on credit default that in turn calls for the code to immediately repay corp indebtedness. Requires reasonable justification that acquirer's slate in GF is not a reason to activate the proxy pite. 2. The Revlon moment. Case hashtag Revlon Incorporated v. McAndrews Forbes Holdings. No BOD breach in application of poison pill, but when BOD decided to sell selection of White Knight and negotiations were motivated by reasons not consonant with shift in duties from corp bastion to auctioneer and should have attempted to negotiate for best share price and not do just the apostasy to lock up / no shop agreement to terminate of merger with White Knight to detriment of hostile proprietary market and SHs. Case hashtag Paramount. Defensive measures with no plan to change control, break up, abandon bus. Doesn't to invoke Revlon FD? And unocal credit default for defining BJR review of takeover offers. A. Note on when Revlon applies a change in control B. Breakup C. Heighten FD in events of change in control / breakup because new decision maker can affect SH value significantly. D. Breakup renders FD to auctioneer for best share price. 85. E. Change in control X. In Paramount Viacom I, elect DERS 2. Breakup 3. Merge with another 4. CSH out V, amend COI 6. Sell substantially all assets 7. Materially alter nature of company 8. Materially alter SH rights B. Note on defensive maneuvers outside of DEC, protecting the deal. Case, Omnicare. D. Note on force the vote provision. Requires target to seek approval of a quit ion by a third party until the org transaction has been voted on by SH. 4. State takeover statutes. A. 1C generation, most restrictive, seminal case Edgar v. IL. Holding might it's unconstitutional, the string commerce clause and supremacy clause. B. Second generation, less restrictive. 1. Control share acquisition statutes. Acquirer can't vote their shares over threshold, i.e. for acquisition. See CPSAL case. 2. Williams Act. Pre-commencement notice provisions repealed because advantage created. 3. Fair price statutes in two-tier tender offer bidder to pay highest price it paid for shares W/ in 2 years. C3 RD generation provides for waiting period. Waiting period, bus combination. Statutes prohibit merger transaction for waiting period unless conditions met. New York WI, Amanda case finds constitutional because interest neutrality / choice D, disgorgement, provision. OH requires EA Public Corp to have a classified BOD. E. Constituency statute BOD can consider outside SH dollar in resistance to takeover F. Pill validation statutes, opt-in statutes, type of anti-takeover statutes. CH15, distributions to SH page 1139. 86. 1. Divs. 2. Repurchase. LG, dollar reserve cap structure 3. Inflated salaries 4. Prorated share at dissolution A, DIV policy. 1. Issue 1, suit to pay. 2. Issue 2, improper. B. Elements of DIV policy. 1. Income mature, stable long-run dividend payout ratio. 2. Growth code dividend payout 3. Info in dividend and stock repurchases A. Announcement of DIV imply POS MNGMT outlook of earnings B. 3 viewpoints I, conservative 1. DIV raise, co-value 2. Middle 1. DIV has no difference in co-value 2. Theorists argue that investment policy borrowing policy to support dividends because issue stock-div is transfer and noten in value cap market 3. Radical 1. DIV lower company value 4. SH that wants steady income prefer DIV rather than selling stock and urge company to raise dividend then invest in bigger co because of risk of lower efficiency. B. Judicial review of dividend policy. A. Publicly held companies with a controlling SH. Case hashtag Baron v. Allied Artist Pictures Corp. 1975. B. A close coring SC Dodge v. Ford. 2. Smith v. Atlantic Property. C. Limitations on DIV under Creditors' Rights Law. I. NYBC Laws $102. 87. 2. Creditors' Rights Enforced by Fraudulent Conveyance Act $112453. BK Code $101.548C. Traditional Statutes. Earned Surplus Statutes. A. Note on the Earned Surplus Test. I. Definition. The portion of surplus is equal to the value of net profits, income, gains, and losses from the date of incorporation after deduction/subsequent distributions to shareholders and transfers to stated cap and capital surplus made out of earned surplus. 2. They're formulating retained earnings but calling it accumulated income for earned surplus. 3. Model Act Formulation 1969, page 1159, above formula, was dropped in all but a few states. B. The modern dividend statutes for corporate I, Cal Corp Code SS 114, 166, 500 to 503, 507. 2. Model Bus Corp ACT SS 1.40, 6, 6.403. DEL LLC Act S 18-607, A, 4. ULLC Act S 405V, simplify use regarding other assets to liability ratios of relevance. 6. Avoid par, stated cap, and exceptions. 1. Nimble DIVs. 2. Spec, repurchase. 3. Depletion dividends. 4. Fictions treasury shares. 7. Avoid payment of DIV when liabilities exceed assets. 8. Cummert discusses modernization W/additional examples of exceptions and restrictions, i.e. dividend, between related entities. C. Contractual restrictions on the payment of dividends, article by Payless Manning, and J. Hinks, I. Industry Practice 1. Involuntary credit, trade credit, short-term lenders take protections for dividend law as it's found without legislative pressure for improvement. 2. Institutional lenders impose contractual restrictions on DIV to compensate. 2. Form of bond indenture provision restricting dividends, page 1163D. Liability of directors, managers, SH, and members for improper distributions, i.e. DIV/repurchase. E. Under Corp Law, I tend to find BOD liability. F. Under Law Protecting Creditors' Rights, I tend to find SH liability. G. DGCL S 172 and 4, use GF. Professional competence H, NYBCL S 719 I, MBCA $8.33. J, ULCA S 406. 88. D. Repurchase by a corporation of its own stock. A. Financial problems. B. Unfair. C. Manipulative. D. Substantial tax advantage. See example whereby cap gains paid later, no DIR tax now. E. Financial limitation on stock repurchase. A. NYBL S 513-15B, DGCL S 162C, MBCA S 1.40, B. 6.40D, Cal Corp Code S 510, A. E. General Rule. Repurchases transfer dollar from Corp to SH and indistinguishable from creditor's perspective from DIV, hence these fall under distribution limitations. F. Exceptions. I. Allowable purposes. 1. Elimination of fractional shares. 2. Collecting or compromising a SH indebtedness to Corp. 3. Paying dissident SH for shares. 4. Redeeming convertibles. 2. Installment payments from installment contract to purchase shares. 3. Funds legally available, not surplus. Pref SH rights to require redemption for. ThoughtWorks case. Preferred SH demanded redemption in court, confirmed legally available funds, not surplus, and defer to BJR unless pleading shows bad faith or fraud. G. Notes on law of creditors' rights. I. Insolvency. Inability to pay debts as they come due. Equity meaning which was applied by Court of Equity before BK Code. 2. Insolvency. Liabilities in excess of assets, aka balance sheet or network list. Bankruptcy meaning. H. Fraudulent conveyance laws to dividends. Dividends subject to foreclosures. I. Unreasoned small capital J. Insolvency under dividend statutes page 1151K. Limitation on dividends under the Corp statutes. I. Intro 1. I. In general, objective test employed, but court deciding corp power to pay dividends to. Who does Corp DIV law protect? DIV improper when it deprives creditor and preferred SH, or Corp. 3. Traditional and modern dividend statutes. A. Capital impairment test, aka cap and surplus or ball sheet test. B. Earned surplus, aka income statement test. 4. Capital impairment test and its meaning. A. DGCL S 141, 154, 170B, NYCL S 102, A. 9, 12, 13, 506, and 570. 89. C. Legal capital and par value. I. A share price at which share was expected to be sold by Corp, i.e. SS 36, 2. Purely nominal amount expected to be sold by Corp, i.e. $1.03. No par stock. 4. Difference between no/low par and what price at which stock will be sold is artificial but relevant to traditional capital impairment statutes. V. Economic capital is the amount investment in company. 5. Structure of traditional statute. Insolvency test. I. Creditors' rights law. 2. BK Code, if A greater than L, and UFTAB, capital impairment test. Dividend cannot be paid if before or after the corporation's assets would be sum of liabilities and legal capital. C. Or D. Liabilities, capital and liquidation preferences. E. Prohibits dividends from legal capital. F. Pays only on surplus. 6. Note on revaluation of assets. A. Klang v. Smith's Food and Drug CTR. B. Randall v. Bailey C. Cases stand for pleading requirement of bad faith, fraud. Otherwise, court defers to management discretion because statutes is not prescriptive. D. Problem with method is GAAP's cost accounting method. E. Assets equals historical cost amortization/depreciation is not FMV. 7. Exceptions to the basic capital impairment test. A. Nimble dividends. If capital impaired, dividend can be paid out of current profits. I. DGCL S 170B. Wasting asset core. I. Note on wasting asset core. 1. Gross rev, depletion surplus. 2. Unless coal mine, oil, rock quarry, patent which is a non-replenishable asset. C. Dividends out of capital surplus. I. In New York Bus Corp Law SS 102, A. 9, 13, 14, 510, 516, 522. DGCL S 154, 170, 242, A. 3, 244D. Note on DIV out of cap surplus. I. Surplus and redux surplus avail for dividend per traditional cap impairment statutes.
Okay, that's finally it. That was a lot in the last section about mergers and then about the dividend policy. I'm gonna end this recording. I'm not gonna extend it by going over all the note cards that I wrote.